from daily list. There is one item serial fee.
You are seeking adjournment?
No, I am not seeking. If it
then
is
why
taken
do you
up,
need to
no,
mention?
I am only making information that if it is taken up in second half, someone on my behalf will make a prayer for tomorrow because due to some personal difficulty, second half I will not be able to remain here. That is the only thing I want to convey.
Please don't waste my time early in the morning. Anybody who has personal difficulty, we adjourn the cases. If you don't want to do it, you don't do it. It's your problem.
No.
Anybody in personal difficulty, why do you have to mention in the morning? I just don't understand.
I want it properly.
Don't mention any case from the list in the morning. Please don't. All mentioning rejected from the list. Tell me, call for it.
Out of term and 89
No.
exactly similar cases
No.
is settled by this.
Actually, call for it.
This case item 6, WPS 900 of 2023.
Yes, petitioner. Sorry?
Senior is on his
Pass over. 12 o'clock. Rather 12:30.
Corpus filing item 1, WPS 7257 of 2023.
Issued by last order in Lordship and directed to file this supplement regarding the closure report.
Yes.
I have received it today itself. The petitioner is here. I will file it by today.
WPL number 7257 of 2023. Counsel for the petitioner seeks adjournment. May prays for and is granted time till 4th of March 2024 to comply with the order dated 4/3/2024. Post on 8th of March. Next. 8th April.
Item 2, WPS 129 of 2023, along with item 3 to 5.
Pass over. 12:30. अब हो गया pass over. Next call.
Item 7, WPS 2030 of 2023.
Yes, petitioner.
Yes. Prayer in the read petition my lord. For correction of the marks obtained in the matriculation column my lord, the marks obtained by the petitioner has wrongly been entered in the merit list my lord. 104 नंबर मात्र इनका इंटर किया गया इन प्लेस ऑफ ये जो इनका जो टोटल मार्क्स स्कोर किए थे वो 408 था।
बताइए कहाँ से? मैट्रिकुलेशन में कितना मार्क्स एलोकेटेड?
हाँ, मैट्रिकुलेशन में
Where is your matriculation certificate?
यस मार्कशीट पेज नंबर 26 मैडम
Yes, 26.
प्लीज नेक्स्ट
This is your matriculation certificate?
यस
Flag नहीं है. What marks did you obtain in matriculation?
मैडम 408
Where do I get this?
but the total marks madam annexure 1 page 26 madam in the aggregate marks के
Aggregate,
नीचे का जो
408.
कॉलम है that is 408
Out of
out of 900
900.
yes this is second division madam
I do not know. The second division?
हाँ
Yes, mentioned here only.
yes in the mark sheet it is itself it is mentioned
Okay. Then
now madam the merit list which has been
you are
prepared
not the
madam
merit list. What is the criteria for allocation of marks?
in the matriculation
No. The merit list which has been prepared pursuant to
Yes.
the some recruitment process,
Yes, madam.
where is that
Yes.
criteria?
Under the rule, my lord, the teachers appointment rule, the rule 19,
Where is it?
the rule I have annexed, my lord. The teachers appointment rule. Well, the rule 21, kindly see rule 21.
21.
Yes, page 40. रिक्त पदों पर शिक्षकों अनुदेशकों की नियुक्ति हेतु निम्नलिखित प्रक्रिया के अनुसार जिला स्तर पर मेधा सूची तैयार की जाएगी। इंटर प्रशिक्षित शिक्षकों की नियुक्ति हेतु मेधा सूची का निर्माण रोमन 1। इंटर प्रशिक्षित शिक्षकों की नियुक्ति हेतु कोटिवार मेधा सूची अभ्यर्थी के कुल मेधा अंक के आधार पर जिला शिक्षा स्थापना समिति द्वारा तैयार की जाएगी। कुल मेधा अंक अभ्यर्थियों के शैक्षणिक मेधा अंक एवं शिक्षक पात्रता परीक्षा के अंक का जोगफल होगा, जिसकी गणना निम्नवत होगी। मतलब दी शैक्षणिक मेधा अंक में जो इनका मैट्रिक, इंटर, टीचर ट्रेनिंग प्लस स्टेट का जो मार्क्स होगा, दैट विल बी एडेड फॉर मेकिंग दी फाइनल मेरिट लिस्ट।
That's right.
नाउ शैक्षणिक मेधा अंक के निर्धारण हेतु अभ्यर्थी के मैट्रिक परीक्षा, इंटरमीडिएट परीक्षा, यही मैट्रिक वाला जो मार्क्स है 408 के जगह में सिर्फ 104 को ऐड किया गया था।
कहाँ पर? नहीं, एक सेकेंड, ये जो है अंक कितने मिलेंगे इसमें? 90% से ऊपर होने से 10 अंक, 80% से 80 to 90%।
दैट इज फॉर टेट।
That is for TET.
That is only for teacher eligibility test में जो मार्क्स करेंगे।
Where is the entry made?
Yes.
Where is the entry made?
Yes. Just.
एंट्री दिखाइए इनका।
हाँ दिखा।
इतना स्लो स्पीड में नहीं चल सकते हैं आप। ये सब
Yes,
चीज तो
ma'am.
आपके टिप्स में होना चाहिए। Where is the entry which you want correction?
है
हाँ, बताइए कहाँ? You have not gone through your brief at home. यहाँ बैठ के पहली बार बड़े डर लग रहा है।
5 मिनट के लिए खाली पास उधर कर दिया जाए। 5 केस के लिए हम तुरंत करें उसको निकाल दें।
5 मिनट के लिए नहीं होता पास होगा, 12:30 बजे आएगी।
ठीक है सर।
नेक्स्ट केस।
Item 8, WPS Q191 of 2023.
Really should this matter be posted after holy vacation. The arguing counsel is not with. Yesterday also I submitted that only in leadership. We could not able to come to the court.
Who is your arguing counsel?
Mr. Arun Kumar. It's a genuine prayer leadership.
Learned counsel for the parties are present. The counsel for the petitioner seeks adjournment. From the perusal of the records of on the ground that Mr. Arun Kumar, the arguing counsel, is not present. He submits that the matter be posted after court. From the perusal of the prayer made in the petition, the petitioner is basically challenging the condition of the advertisement, wherein the minimum age limit has been fixed as 40 years as on 1/8/2015. The selection process is over.
No, it's going on. Lordship, state counter is also necessary.
How this
Because the-
advertisement can be changed? I don't understand.
So far as reference date is concerned, Lordship, this is a policy decision, and JPSC has bound to follow the rule also. So the state is now required to file counter application.
A counter affidavit has been filed by JPSC indicating that the cutoff date in the advertisement is essentially a matter of policy.
Yes, Lordship. Before publishing the advertisement, Lordship, JPC has sent a letter seeking opinion to change the reference date. Lordship.
The Learned Counsel for JPSC
Government
has submitted that. At the time of advertisement itself, necessary communication with the state was made, and the state had communicated that there is no requirement to change the cut-off date in the advertisement. He has submitted that the recruitment process arising out of the state advertisement is still going on. Correct?
Yes.
Since the petitioner is seeking adjournment on ground of personal difficulty of arguing counsel, Mr. Arun Kumar posed this case on 1st of April to be taken up as the first case. Next.
From daily list for
First case
final,
at 10:30.
from daily list for final report, item 1, the LPR 3043 of 2022.
Yes, petitioner.
Challenges to the notification of reference itself.
Private respondent has filed counter.
They have filed counter. State was also directed to file counter. They have also filed counter.
State has also filed counter.
They have served a copy yesterday.
Not yet filed because it was not there in my record.
They have served a copy yesterday.
Where is the state? Where is the state? Do you want to respond to that?
No, we don't.
No problem. If they want to argue, it's okay. Otherwise, you argue.
There are two prayers. In the alternative, first we have challenged the reference itself made by the state government. On the ground,
He is appearing in person.
he is appearing in person.
आप हिंदी में समझेंगे कि इंग्लिश में?
हम हिंदी में
आप हमको एक बात बताइए, आपका इंडस्ट्रियल डिस्प्यूट चल रहा था, है ना? इन द मीन टाइम इन्होंने आपको एक शो कॉज किया, डिसिप्लिनरी प्रोसीडिंग इनिशिएट की, उसके बाद आपने पेंडिंग इंडस्ट्रियल डिस्प्यूट में ये बोला कि इसको जो है मतलब नहीं होना चाहिए, तो आपने एक 33 कैपिटल ए का एक प्रोसीडिंग इनिशिएट किया, ठीक है? उस पर कोई ऑर्डर हुआ? ऑर्डर नहीं, जस्ट उसके बाद इन्होंने आपको डिसमिस कर दिया, प्रोसीडिंग करके चाहे कैसे भी, ठीक है? इन्होंने उसके बाद एक एप्लीकेशन फाइल की कि इनके एक्शन को कंफर्म किया जाए, राइट? वो मैटर वहाँ पेंडिंग है, यस या नो? पेंडिंग है। तो जब वहाँ वो मैटर पेंडिंग है तो फ्रेश रेफरेंस कैसे होगा? पहला चीज, एक सेकेंड, फ्रेश रेफरेंस कैसे होगा? दूसरा चीज, अगर फ्रेश रेफरेंस होगा, अगर आप चाहते हैं कि फ्रेश रेफरेंस में ये चीज़ डिसाइड हो, तो फिर आपको वो प्रोसीडिंग को छोड़ना पड़ेगा। दोनों चीज़ तो नहीं कर सकते ना।
उसको छोड़ चुके हैं।
आपका स्टेटमेंट आप दीजिए दैट यू विल नॉट परस्यू दैट।
हम छोड़ चुके हैं।
एक सेकेंड, दैट शुड बी सफिशिएंट। If he makes a statement that he will not pursue his case under section 33A or whatever in the pending industrial dispute, then you should be happy.
there is another petition जो हमारा केस है 33(2)B proviso में, because the act says that if there is अगर pending case है, पहले से reference 1(17) था, तो punishment order में भी last paragraph में हम लिखे हैं कि हम application दे रहे हैं, simultaneously 1 महीने का check दे रहे हैं, क्योंकि वो एक्ट का प्रोसीजर है। वो पनिशमेंट ऑर्डर फाइनल इफेक्ट तभी आएगा जब अप्रूवल होगा। जो ऑर्डर है लेबर कोड का, उस पे भी दैट इज आल्सो करेक्ट, वो ऑर्डर भी सही है, लेकिन हर बार ऑर्डर यही कहता है कि जब अप्रूवल हो जाएगा उसके बाद ही तो रेफरेंस करेंगे। अभी तो वो पनिशमेंट ऑर्डर इनकोएट है, वो कंप्लीट ही नहीं हुआ है, क्योंकि प्रक्रिया है कि अगर पेंडिंग केस है पहले से, तो आपको उसी कोर्ट में डिसमिसल ऑर्डर के साथ-साथ साइमल्टेनियसली
The dismissal order takes its effect, it is post facto approval.
इट इज पोस्ट फैक्टो अप्रूवल, क्योंकि नॉट कनेक्टेड था। अगर कनेक्टेड रहता तो इनका कहना था कि कनेक्टेड है, इसलिए ये पहले ही 33A में चले गए। हमने कहा कि नहीं, कनेक्टेड नहीं है, वो जनरल नेचर का,
33A he is abandoning.
ही इज अबैंडनिंग, लेकिन 33
So far as the subsequent is concerned, he wants that it should be adjudicated in a separate reference case. What is your problem about it?
I have no problem. Then 33(2)B का then compliance को मान लिया जाए कि compliant है, क्योंकि वो
He will have
approval
no objection
application
to that.
बट वो लॉ का प्रोविजन है, देयरफॉर सब्सिक्वेंटली कहीं ये नहीं क्वेश्चन उठे कि 33(2)B में तो पनिशमेंट ऑर्डर का कभी अप्रूवल ही नहीं हुआ, वो पोस्ट फैक्टो अप्रूवल नहीं हुआ, तो उसका रिलेशन ये होगा कि सब इफेक्ट ये होगा कि वो अपने आप में इनवैलिड हो
टेक्निकली
जाएगा।
व्हेन 33(2)B में जब अप्रूवल के लिए भेजते हैं आप लोग, at that point of time they scrutinize the procedure also and it is treated as a reference.
33(2)B में नहीं, 33A में बोलता है कि इनको रेफरेंस की तरह डिसाइड
हाँ,
करेंगे।
हाँ।
33(2)B प्रोवाइजो बोलता है कि वो देखेंगे खाली प्रोसीजर फॉलो हुआ है कि नहीं, नेचुरल जस्टिस देखेंगे, इंक्वायरी,
That's
और
right.
ये देखेंगे कि विक्टिमाइजेशन है कि नहीं। अगर
इतना
वो
ही तो देखते हैं,
हाँ, वही
बाकी
देखेंगे।
इंडस्ट्रियल डिस्प्यूट में देखते ही क्या
नहीं, लेकिन वो अप्रूवल दे भी देंगे तो अप्रूवल देने के बाद ये रेफरेंस कर सकते हैं, लेकिन अगर वो अप्रूवल नहीं देंगे तो वो अपने आप खत्म हो जाता है, मेरा पनिशमेंट ऑर्डर चला जाता है उसी समय। तो अब अगर ये प्रोसीजर नहीं फॉलो होगा तो ये तो 30 कहीं बाद में रेफरेंस डिसाइड होने के बाद ये ग्राउंड न उठे कि ये तो 33(2)B में हुआ ही नहीं अप्रूव, तो डिसमिसल ऑर्डर का पोस्ट फैक्टो अप्रूवल नहीं होने के कारण डिसमिसल ऑर्डर गलत हो गया। तो यहीं पे हम
You see,
जुरिस्डिक्शनल एरर
no,
में फंस रहे हैं।
just the approval is a post facto.
हाँ, पोस्ट फैक्टो,
Right.
बट इट इज स्टिल रिक्वायर्ड अंडर द लॉ एज पर प्रोसीजर।
And unless the approval is granted, no reference can lie.
That is what we are saying. That is what the
Show
judgment
me some law with judgment that unless that approval is granted, no reference can lie. We will expedite that also approval part. What is the stage?
वहाँ पे जज नहीं है, इसलिए हम बोल रहे हैं कि his predicament is genuine, पर ये convenience के लिए हो रहा है, जबकि
No,
जो
you show us some law that unless that approval is granted, right, the order does not take its effect. And what is the scope for examining the approval with regard to termination pending any other proceeding before the labor court? Show me which judgment are you citing?
it's citing एक recent judgment है, paragraphs 13-14 राजस्थान स्टेट रोड एक्ट कॉपी,
Supreme Court?
सुप्रीम कोर्ट।
उनको भी दीजिए फिर.
उनको
He also needs to know that. Which paragraph are you referring?
paras 13 and 14।
Kindly read it.
At the outset, it is required to be noted that the workman was subjected to departmental inquiry and the charge against the deceased workman was not issuing the tickets to 10 passengers, though he collected the fare. On conclusion of the departmental inquiry, his services were terminated. The termination was the subject matter of the approval application before industrial tribunal in an application under section 33(2)B of the
Same
IDA.
here. इसमें भी वही है हमारे प्रेजेंट केस में.
हाँ. In the said proceedings, the management was permitted to lead the evidence and prove the charge/misconduct before the tribunal. In the said application, the parties led the evidence, both oral as well as documentary. Thereafter, on appreciation of evidence on record, the industrial tribunal, by order dated so and so, approved the order of termination. That thereafter, workmen raised industrial. यहाँ तो in fact
Kindly read it.
हाँ.
Kindly.
Industrial tribunal proved the industrial by order dated thereafter. Once the order of termination was approved by the industrial tribunal and the management was permitted to lead the evidence in that case and prove the misconduct before the court, and thereafter on appreciation of evidence the order of termination was approved. Thereafter the fresh reference under section 10 of the ID Act challenging the order of termination was not permissible.
That's right.
It is
So
required.
therefore,
उसका
that
discretion है.
particular proceeding, right? What is the purpose of that approval? That approval is that there should not be any separate reference that the workman should not suffer, right? That is, we have also passed in judgment. I do not know, आप तो हाई कोर्ट का जजमेंट पढ़ते नहीं है, सुप्रीम कोर्ट का ही खाली जजमेंट पढ़ते हैं. अब उसका तो हम कुछ कर नहीं सकते हैं.
अदरवाइज भी जो चोलन रोडवेज है वो बोलते हैं कि आप रेफरेंस कर सकते हैं, बट आफ्टर दी अप्रूवल, अगर अप्रूवल होगा तभी तो रेफरेंस करेंगे, अदरवाइज तो
ये
उसी में
चोलन
रेफरेंस का सारा
है
स्कोप है.
जजमेंट. कब का जजमेंट है वो?
ये तो जजमेंट है, ये तो एकदम रिसेंट है. इनफैक्ट ये तो
नहीं, चोलन रेलवेज कब का जजमेंट?
चोलन रेलवेज 2005 का है, वो इम्प्यूग्ड ऑर्डर में कोटेड है. क्योंकि हम ऑल्टरनेटिव में ये भी प्रेयर दिए थे कि आप कम से कम रुक जाइए, वहां पे डिसाइड होने दीजिए, क्योंकि वो हायरार्की में भी आपसे ऊपर है।
Once you apply for approval, right? The court is bound to see the material and then grant approval.
Correct.
Or not grant approval, right?
Correct.
So that is basically an adjudication in terms of in the contours of section 10 itself.
Correct.
Right?
So
So
the-
once that proceeding will take its effect, then under such circumstances we can say that the present reference would not be maintainable because they will have to pursue their remedy in that.
Correct.
और जो इनको बोलना है वो उसमें बोलेंगे, everything they will say, whatever they have to say. यही है ना?
हम तो ये भी एप्लीकेशन दिए कि क्योंकि वो प्रीवियसली इंस्टीट्यूटेड है, आप सेक्शन 10 सीपीसी का प्रिंसिपल अप्लाई करके
इनको
वेट
जरा
करिए।
समझाने दीजिए ना। इन्होंने आपको टर्मिनेट किया, टर्मिनेट करके अप्रूवल के लिए इंडस्ट्रियल ट्रिब्यूनल में अप्लाई किया, ठीक है। इंडस्ट्रियल ट्रिब्यूनल जब वो मैटर को देखेगी, उस मैटर में वो देखेगी कि इन्होंने सर्विस रूल्स के हिसाब से किया है कि नहीं, आपका विक्टिमाइजेशन किया है कि नहीं, आपका रूल्स ऑफ नेचुरल जस्टिस का वायलेशन है कि नहीं, आपको अपॉर्चुनिटी दिया है कि नहीं, ये सारी चीज़ें वो वहाँ पे देखेगी, राइट। अब जो आपने नया प्रोसीडिंग यहाँ पे किया है, ठीक है, तो जो आप यहाँ पे इस प्रोसीडिंग में करेंगे वही सारी चीज़ें उस प्रोसीडिंग में होनी है, क्योंकि किसी भी वर्कमैन को जिसके अगेंस्ट में कोई भी इंडस्ट्रियल डिस्प्यूट्स पेंडिंग है, उसको कोई भी एक फ्रेश प्रोसीडिंग करके टर्मिनेट अगर करता है मैनेजमेंट, तो वहाँ पे जाके उनको अप्रूवल कराना पड़ता है, ठीक है। देयरफॉर अंडर सच सर्कमस्टांसेस जब वहाँ पर अप्रूवल होगा, प्रोसीडिंग होगा और आपको एविडेंस भी लीड करना है, आपको सब कुछ जो आप इस प्रोसीडिंग में करना चाहते हैं वो सारी चीज़ें आप उस प्रोसीडिंग में कर पाएंगे, तो फिर इस प्रोसीडिंग को कंटिन्यू करने का क्या मतलब?
जब हमको सस्पेंड किया गया तो डीएससी के पास हमने प्रार्थना की, वहाँ भी से भी इन लोग को बुलाया गया तो ये लोग गए नहीं।
उनको जाना ही पड़ेगा ना,
उसके
क्योंकि
बाद में जब वहाँ हम लोग किए मिस केस तो दो को नोटिस हुजूर आया, लेकिन दोनों नोटिस को इग्नोर कर गए, दोनों नोटिस में नहीं गए। अंतोगत हम प्रेयर करते रहे, निवेदन करते कि भाई हमको अभी सस्पेंड किए हैं, ऐसा ना, तो इन्होंने लिख के दिया है कि मैं आपको निकाला नहीं हूँ। लेकिन जब वहाँ जज साहब छुट्टी थी, मैंने रिटायर कर गए, तो उसके बाद ही जाते हैं एक आवेदन दिए या नहीं दिए, हम लोग को तो
दिए
पता
हैं।
नहीं। दिए हैं,
आपने जवाब दाखिल किया है
जी
ना?
हाँ, तो
आवेदन दिए हैं वहाँ
दिए। उसके बाद में ही कोर्ट में कोई नहीं था, बंद था कोर्ट।
देखिए, अगर मान लीजिए कोई कोर्ट बंद होगा तो दूसरा कोर्ट में केस चालू हो जाएगा, ऐसा नहीं होता है ना?
नहीं, कोर्ट बंद है, उसी दरमियान हम लोग को तो कोर्ट चालू में हम लोग आवेदन किए थे।
हाँ।
और उसमें दो नोटिस इनके पास गया, दोनों नोटिस में शामिल
नहीं, आपकी बात बिल्कुल सही है, वो शामिल नहीं हुए। तो कोर्ट में अगर कोई शामिल नहीं होता है, स्टेट काउंसिल नहीं आए थे, तो हम उनका इंतजार थोड़ी कर रहे थे, उनके खिलाफ हम ऑर्डर कर सकते हैं उनके बिना,
जी,
है नहीं? तो जब इसीलिए जो रेफरेंस जो किया है ड्यूरिंग द पेंडेंसी ऑफ दैट मतलब दैट पर्टिकुलर प्रोविजन, तो वो तो आपका तो सारा ग्रीवेंस उस प्रोविजन में कंसिडर होने ही वाला है।
उसमें तो केवल हम सस्पेंड हुए थे ना, उसमें निकालने का कोई
नहीं, निकालने के बाद इन्होंने आपको
जी
भेजा।
नहीं, हम तो जो
एक
किए थे ना,
सेकंड देख लीजिए।
Annexure 3 है पेज
एनेक्शन 3 जरा निकालिए जरा।
हम जो मिस केस किए हैं वो सस्पेंड
आपका बात नहीं है, आप इसका जवाब दाखिल कर दिए हैं ना? पिटीशन का जवाब दाखिल किए हैं कि नहीं किए? शायद याद नहीं है भाई, आप सक्षम नहीं है कोर्ट में बहस करने के लिए। अच्छे वर्कर होंगे आप, तो हमको किसी को एमआईके से अपॉइंट करना पड़ेगा। अगर आपको ये नहीं पता, आप
दिए
लिखे
हम और जवाब दिए हैं, यहाँ तो दिए हैं।
ये बताइए पेज नंबर 84 का क्या जवाब है, एनेक्शन 2 का क्या जवाब है, बताइए। एनेक्शन 2 का क्या जवाब है, बताइए। Yes, state, are you there? Yes?
Lordship, the very first case which was filed by the respondent number 1, Lordship, that was case number 1 of 21 under section 33(2)(b).
Case number
Case number
1 of
1 of 21.
पैरा 21 में हम दे दिए
एक
रिट में
second.
विथ डेट्स इन माय रिट पिटीशन.
नहीं, एक सेकंड. Miscellaneous case number 1 of 21. It was filed by whom?
Filed by the respondent.
Respondent, no?
1.
Under section 33A.
33(2)(b).
नहीं नहीं.
3A
33A का है वो petition,
Yes, Lordship.
right? Page number 65,
Yes.
right? And thereafter he was dismissed.
There, it was Lordship prior to dismissal. This case was
Certainly, the moment the charge sheet was issued, he filed a case.
Yes, Lordship. It
That
was
is a
prior to
provision.
dismissal.
There is a provision for that, right?
Thereafter,
Thereafter, they dismissed him.
yes,
They filed miscellaneous case number 2 of 21,
yes, Lordship.
right?
And thereafter, they had filed another case before the industrial tribunal, bearing the reference number 3 of 2014. Another case bearing reference number miscellaneous case number 2 of 2020.
This is filed by the management.
No.
No, it is filed by the management. Have a look at it. Page number 84
Yes, Lordship. It was filed by the management seeking approval
of that order of termination,
termination.
dismissal,
Yes.
right? During the pendency of this petition, how a reference can be made? Because now this particular petition, miscellaneous case number 2 of 2021, will be decided scrutinizing everything.
Yes.
It is as good as deciding the reference itself. And the law provides for approval.
Ownership, because there are two different cases. One is before it was filed by the respondent number 1 prior to dismissal, and another was filed after the dismissal.
No. Respondent number 1 did not file any case after dismissal.
Lordship.
Which case? What is the case number filed by the respondent after dismissal? Give me the case number.
Industrial dispute, industrial tribunal bearing case number reference number 3 of 14.
3 or 14.
Reference number 1 of 2017.
This is the original case,
Yes, sir.
which is pending decision. In that pending proceedings, only these two miscellaneous application has been filed.
because 117 was
Please
pending.
hold on. Because 117 was pending. आपका क्या नाम है?
Lordship, I was on election reporting that.
So you should arrange somebody to seek adjournment. You should have more juniors because you have many cases to argue. Then कुछ नहीं पता है. कोर्ट का खाली टाइम वेस्ट करने के लिए ऑर्नामेंटल खड़े हुए हैं. आपसे पूछ रहे हैं, आपने एक ही केस किया है. एक तो इंडस्ट्रियल डिस्प्यूट पेंडिंग था 2017 से. रेस्पोंडेंट आप ही से पूछ रहे हैं. 2017 से एक केस पेंडिंग था. उसके बाद आपने मिसलिनियस केस 1 to 2021 का फाइल किया जब इन्होंने आपको शो कॉज किया, राइट? उसके बाद भी कोई केस किया है क्या?
जी उसके बाद
नहीं किया है ना?
रेफरेंस में हम गए हैं
नहीं, उसके बाद रेफरेंस में गए
जी
जो इसमें कंसिडरेशन पर है.
जी।
उसके अलावा तो कोई केस नहीं किया
जी,
है ना.
नहीं।
ठीक है. तो जब इन्होंने ये केस कंफर्मेशन के लिए कर दिया, आपके अनुसार कंफर्मेशन की जरूरत है कि नहीं है बता दीजिए. अगर आप बोल देंगे कंफर्मेशन की जरूरत नहीं है तो आपका रेफरेंस का केस चलेगा. लेट हिम से दैट नो कंफर्मेशन इज रिक्वायर्ड. इन्होंने जो आपके खिलाफ जो ऑर्डर लिया है किया है उसमें उनको कंफर्मेशन की जरूरत थी कि नहीं थी? अकॉर्डिंग थी. तो जब ये कंफर्मेशन की जरूरत है उस प्रोसीडिंग में तो वो सारा कुछ देखेंगे ना. कि आपको विक्टिमाइज
ये कह रहे हैं हुजूर कि जब हम कोर्ट बंद था ये लोग किए, उसके बाद में हम कोई बोले कि हम नहीं निकाल रहे हैं, तो ये उसके बाद में हमको जब निकाले तो हम डीएलसी के यहाँ गए, डीएलसी के द्वारा ही
आपकी बात सही है, डीएलसी के यहाँ गए
जी
तभी ना इस कोर्ट में आ गया
जी।
यहाँ पर।
और
हम आपसे
इसमें-
सिर्फ इतना चीज पूछ रहे हैं, ये तो बहुत जानकार है अंजनी कुमार जी, आप ही जरा बताइए, जब कोई डिसमिसल होता है, ठीक है, ड्यूरिंग पेंडेंसी ऑफ रेफरेंस, तो वहाँ कंफर्मेशन होता है ना?
जो 2A को देखा जाए, जो अमेंड हुआ 2010,
हाँ
तो उसमें है जो कि डिसमिसल, रिट्रेंचमेंट अगर इंडिविजुअल वर्कमैन का होता है,
हाँ
तो जैसे ही उनको डिसमिसल ऑर्डर हो गया, उनको डीएलसी के यहाँ जाना है। और इसको देखा जाए जो किताब
2A में मत पहुंचिए, 33 बढ़िया। अब आपको तो कुछ पता ही नहीं भाई, देखिए आप लोग से होगा नहीं, हमको एमाइकस अपॉइंट करना
हुजूर, 1 सेकंड से हम ज़्यादा नहीं बोलेंगे। पास उसमें 2A में अगर हम नहीं जाते हैं तो 4 साल से कोर्ट बंद था, तो 3 साल है, 3 साल के बाद हम गए, बाकी जगह अमेंडमेंट है, यहाँ नहीं। एक बार हुजूर देख लिया जाए,
हमको पता है उसमें 3 ही साल का लिमिटेशन।
जी। तो ये तो चालाकी किए
आप
हुजूर।
नहीं कोई चालाकी के
अब-
कोर्ट से कोई चालाकी कर सकता
अब
है?
लोग-
आप हमको बस इतना एक लाइन का जवाब आप हमको
हम
दीजिए।
एक लाइन का जवाब दे रहे हैं। अगर ये जो 1 महीना का जो चेक दिए हैं, क्या हमको चेक दिए, यही इनसे पूछ लिया जाए।
वो तो
वही
वहाँ
तो
देखा
Magistrate
जाएगा ना,
will decide.
वो यहाँ पे नहीं डिसाइड
और
होगा।
दूसरा बात
अब
आप
ये-
हमको सिर्फ एक बात बताइए कि
जी।
इन्होंने जो कंफर्मेशन के लिए वहाँ अप्लाई किया है, ठीक है, उस कंफर्मेशन के दौरान ये जो वर्कमैन है, इनकी सुनवाई होगी कि नहीं होगी?
एकदम नहीं होगी हुजूर।
नहीं होगी?
हाँ, रेफरेंस मेन रेमेडी है, और उस रेफरेंस में
उसमें कोई सुनवाई नहीं
जी
होगी
नहीं,
इनकी।
और उसके लिए रेफरेंस मेन है। अगर ये रहता तो ये जो हम लोग
तो ये जजमेंट गलत है क्या?
कौन
ये जजमेंट
ये हुजूर
नहीं, ये जजमेंट
ये 2010 के बाद का है।
सुप्रीम कोर्ट का जो जजमेंट
और
है
उस
2022 का
सिंग-
गलत हो गया है।
सिंगल वर्कमैन का नहीं है। सिंगल वर्कमैन का जजमेंट जो है वह 2010 में अमेंड हुआ 2A, और 2A जब अमेंड हुआ हुजूर, उसमें है कि डीएलसी को 45 दिन ही रखना है, इसके बाद डीएलसी को रेफर कर देना है। तो वहाँ रेफर हो गया, जहाँ पर इनका जो इंक्वायरी प्रोसीडिंग अवैध हो गया, गलत साबित हो गया। अब तो जब इनका इंक्वायरी प्रोसीडिंग गलत हो गया, अब फाइनल स्टेज में है, तो रेफरेंस को रहा जाएगा जो 2A के तहत, जी, जो कानून है।
तो फिर ये इसका क्या होगा? इन्होंने जो पिटीशन फाइल किया है फॉर अप्रूवल,
ये तो चालाकी हुई कि 4 साल ट्रिब्यूनल नहीं रहेगा, 3 साल लेबर का हो गया, लेबर खत्म हो गया, कहीं नहीं विवाद उठा सकता।
सुन
कोई
लिया।
चालाकी नहीं, मेरा रेफरेंस वही पेंडिंग था। लॉ बोलता है आपको उसी कोर्ट में
हाँ,
एप्लीकेशन
ये स्टेट यू जस्ट टेल अस।
उसी कोर्ट में हमको देना ही है एप्लीकेशन।
हाँ ठीक है, आप लोग बैठ जाइए, सुन लिया आपको। हाँ बताइए।
Since Lordship,
You have not even filed a counter affidavit.
yes, Lordship, because it was filed yesterday. And,
Because मतलब क्या? You are not aware of the High Court rules.
Yes, Lordship.
Then, because means what?
Not be filed because it's not a copy of the other thing, but it should not be filed because of 48 hours.
So why didn't you do it?
We'll file it in court.
Not in course of the day. We are hearing it finally. You argue your case. You file it, we will take it on record. Give it to us. What is your stand? You tell us. See, are you there in this case?
Yes, I am.
You just tell us one thing. Under the provisions of Industrial Disputes Act, during the pendency of a reference case under adjudication, if any proceeding is initiated against a workman, then that particular action has to be confirmed by the same tribunal in the same proceedings when miscellaneous cases to be filed, right? So that they have done by miscellaneous case number 2 of 2021, right? In that case, the tribunal will scrutinize everything and the workman will also be granted an opportunity. Now, during the pendency of this approval of order of dismissal, the workman has instituted a fresh reference case. Is there any likelihood of contradictory orders? Yes or no? The same cause of action is going to be agitated at 2 forums. It cannot be. So this miscellaneous case number 2 of 2021, either you say that no approval is required, I will record your statement. They will not pursue it. You say that no approval is required. But that is a statutory requirement. You will not be able to say. Then, the same proceeding under two jurisdictions. How is it possible?
There are two different issues. One is that they respondents have come against the order of dismissal. One is that, and another is that they are seeking approval. The petitioner having, they are seeking approval for the termination of the respondent lordship. So there are two different cause of action.
No, approval may be, but they will scrutinize everything.
Yes, lordship, genesis is the same, but
No, in approval also the Labour Court will scrutinize everything, whether it's a case of victimization or not.
yes,
Then, merely because the tribunal is not functional, that does not mean that the reference would lie. Anyway, we will decide it's a legal issue. आपको क्या बोलना है बोल दीजिए.
जी पहला जो 2A को देखा जाए.
Okay. I'll record your submissions. Yes.
Notwithstanding anything contained in section 10, any such workman as is specified in subsection 1 may make an application directed to the Labour Court or Tribunal adjudication of the dispute referred to therein after the expiry of 45 days from the date of he made the application to the conciliation officer of the appropriate government for conciliation of the dispute, and in receipt of such application, the Labour Court or Tribunal shall have process and jurisdiction to adjudicate upon the dispute as it where a dispute referred to it by the appropriate government in accordance with the provision of this Act, and all the provision of the Act shall apply in relation to such adjudication as they apply in relation to an industrial dispute referred to by appropriate government. The appropriate government referred to in subsection 2 shall be made to the Labour Court or Tribunal before the expiry of 3 years from the date of discharge, dismissal, retrenchment or otherwise termination of service as specified in subsection 1. तो 3 साल पूरा करना चाहने के लिए ट्रिब्यूनल नहीं थे, फरवरी में रिटायर हो गए और तभी झट से दे दिए ताकि 3 साल तक कोर्ट नहीं रहेगा, इनका अधिकार खत्म.
किनका अधिकार खत्म?
मजदूर का.
कैसे खत्म हो जाएगा?
वही 3 साल है. 3 साल के बाद ये जो है 2A के अनुसार ये नहीं आ सकते. अब इसमें देखा जाए जो सेक्शन 10 का 2A.
ये रेफरेंस सेक्शन 10 में हुआ है.
सेक्शन 10 में
ये तो सेक्शन 10 में रेफरेंस है, 2A में तो नहीं हुआ है.
तो जब 45 दिन में जब वो दबा दिए प्रोसीडिंग के उषा मार्टिन, तो घूस देने में तेज है हुजूर. तब इसके बाद हम लोग
सुनिए, आप जो है ना अपना लैंग्वेज को बहुत कंट्रोल करके
पकड़ाए हैं हुजूर.
पकड़ाए हैं तो आप भेज दीजिए जेल सबको.
जी
है ना.
इसको देखा
इस तरह की भाषा कोर्ट में नहीं चलती है, इसीलिए
मांग रहे हैं. अगर
इस तरह की एक तो आप इस केस में आपको कोई ऑथराइजेशन नहीं है, लेकिन ये जो है चूंकि बहस करने में सक्षम नहीं है इसीलिए आपको बुला लिए, क्योंकि पिछली बार आप इसमें आए थे. लेकिन अपनी भाषा बहुत संभाल के बोलिए.
जी
ठीक है,
माफी मांग लिए हुजूर. थोड़ा सा देखा जाए 2A सेक्शन 10 में 2A का रहता है. एन ऑर्डर रेफरिंग एन इंडस्ट्रियल डिस्प्यूट टू ए लेबर कोर्ट, ट्रिब्यूनल और नेशनल ट्रिब्यूनल अंडर द सेक्शन शैल स्पेसिफाई द पीरियड विदिन व्हिच such labor court, tribunal or national tribunal shall submit in award on such dispute to the appropriate government, provided that where such industrial dispute is connected with an individual workman, no such period shall be exceed 3 months. तो इस 3 मंथ में ही इसको कंक्लूड इनका हो जाना था. लेकिन अब जब ट्रिब्यूनल जब था हुजूर 2 चिट्ठी इनको दिया तो ये नहीं गए. और जब
आपकी ये सारी बातें हम सुन ली
जी, और जब
सिर्फ आप हमको एक ही बात का जवाब दे सकते हैं तो दीजिए, नहीं तो हम लोग अपने से ऑर्डर में जवाब देंगे.
सर
इन्होंने जो अप्रूवल के लिए अप्लाई किया है,
जी,
इनको अप्रूवल की जरूरत थी कि नहीं?
इनको तो निकालना ही नहीं था जब
वो दूसरी-
रेफरेंस के.
अगर मान लीजिए
अब अप्रूवल करना था हुजूर तो डिसमिस करने पर फांसी चढ़ाने से पहले इनको अप्रूवल मांगना था.
प्रायर अप्रूवल होना चाहिए.
हाँ जी, फर्स्ट इनको मांगना था कि भाई हम इनको निकालना चाहते हैं, ये गलती है, हमको दिया।
ठीक,
बस
प्रायर अप्रूवल नहीं हुआ,
नहीं हुआ
बाद में अप्रूवल नहीं हो सकता।
जी, नहीं। जब हम रिट्रेंच हो गए, डिसमिस हो गए, आगे अंदर जाना बंद कर दिए, सस्पेंशन अलाउंस देना बंद कर दिए
बस
जी। और ये जो लेबर कोर्ट का जो लास्ट पारा में जो फाइंडिंग है जो इनको हुजूर जब वहाँ रेफरेंस हुआ था तो इनको WS फाइल कर दिया, बंद लिफाफा उसमें उठाना था, लेकिन ये बंद लिफाफा में WS दिए ही नहीं और लास्ट में वो 2 पन्ना का दे करके हुजूर के यहाँ आ गए, केवल 4 साल समय डिले करने। यही हुजूर से प्रार्थना है।
जी, देखिए, heard the learned counsel for the parties. This writ petition has been filed for the following relief.
There's
The
one good
learned-
judgment on jurisdiction point पे करना है, para 22-23.
हुजूर मेरा भी इसमें कि CPC 10 नहीं अप्लाई
हाँ, CPC नहीं अप्लाई,
दे दिया जाए।
आपका सबमिशन में लिखाएंगे, आपके सामने ही लिखेंगे। ये 2 कॉपी आती है हमको।
एक national engineering में 24 and 27 says कि it has to be decided in Article 2 to 6. Reference can only be challenged. It cannot be challenged before the labor court.
ये दोनों जजमेंट
इसका पैरा 24-20।
Cover Singh Sani
आपको कोई जजमेंट देना है?
दिए
कौन सा?
जो
ये वाला?
हाँ
इलाहाबाद हाई कोर्ट का?
जी जी से CPC ने
इसका पैरा नंबर कौन सा है?
घेर दिया।
अच्छा, ठीक है। Okay. For the learned counsel for the parties, the learned counsel for the this writ petition has been filed for the following relief. The learned counsel for the petitioner, while assailing the reference itself, has submitted that a proceeding under section a proceeding in connection with the respondent workman was pending before the learned industrial tribunal in reference case number 1 of 2017, and on account of unauthorized absence,
followed by unruly conduct and use of abusive language.
on account of certain charges including unauthorized absence and unruly conduct, the charge sheet was issued to the respondent workman, and consequently the respondent workman filed a petition before the case filed a petition in the case pending before the industrial tribunal, which was numbered as miscellaneous case number 1 of 2021. However, no order has been passed in the said case. In the meantime, the proceedings continued and the respondent was dismissed from service. The learned counsel submits that as per the provisions of section 33 within bracket 2 within bracket B of the Industrial Disputes Act, a petition was filed seeking approval of the order of dismissal, and the said case was numbered as miscellaneous case number 2 of 2021, and the said proceeding is pending before the learned Industrial Tribunal Ranchi. However, the Industrial Tribunal as on date is non-functional. The learned counsel submits that in the meantime, the respondent also sought reference to the fresh dispute regarding his dismissal, and the same was referred to the presiding officer, Labour Court Ranchi, in reference case number 6 of 2021 by the respondent state. The learned counsel submits that while deciding miscellaneous case number 2 of 2021, the presiding officer, Industrial Tribunal Ranchi, will have the jurisdiction to consider the legality and validity of the order of dismissal which has been passed during the pendency of reference case number 1 of 2017 and the point, if any, of victimization will also be considered in the said proceedings. The learned counsel submits that in such circumstances, the fresh reference which has been made is not maintainable and there is a likelihood of contradictory orders being passed in the reference case number 6 of 2021, which is a fresh reference, and in miscellaneous case number 2 of 2021. यही है आपका case total. The learned counsel has further submitted that a petition was moved before the learned court in reference case number 6 of 2021. Yes, to stay the proceedings during the pendency of miscellaneous case number 2 of 2021. The same has been rejected by the impugned order dated 6/6/2022. However, the learned counsel submits that the reference itself was not maintainable. The petitioner has not submitted to the jurisdiction of the Labour Court Ranchi in as much as the written statement has not been filed. Filed, not filed. Filed किए हैं?
It was filed subsequently, but we challenged the reference also here.
All right. Has been as some ये last sentence में. The learned counsel submits that we have challenged, the petitioner has challenged the order dated 6/6/2022 passed in reference case number 6 of 2021 as well as the reference itself. The learned counsel has referred to the judgment passed by Honorable Supreme Court reported in bracket 2000 bracket close 1 SCC 371 to submit that the reference cannot be challenged before the Labour Court and the same has to be challenged only in writ jurisdiction. With he has referred to para number 24 and 27. The learned counsel has also relied upon judgment passed by Honorable Supreme Court reported in 2022 SCC online SC 1335 para 13 and 14 to submit that under the provisions of section 33 within bracket 2 within bracket B of the Industrial Disputes Act, the legality and validity of the dismissal of the petitioner will be taken into consideration and therefore the subsequent reference is not maintainable. He has also relied upon judgment passed by Honorable Supreme Court reported in bracket 2012 bracket close 4 SCC 307 para 22 and 23 to submit that no jurisdiction can be conferred even by consent of the parties.
And 23 says that if the act provides a thing to be done in a specified
The,
manner, then the same procedure has to be.
Okay, and it has been held that if an act has to be done in a particular manner, the same has to be done in that manner or not at all, right? ये आपका हो गया. The learned counsel appearing on behalf of the respondent workman has submitted that the reference was maintainable in view of the fact that as per the provisions of section 2 capital A of Industrial Disputes Act, the reference can be made by an individual, the dispute in connection with his dismissal can be raised by the individual workman only within a period of 3 years from the date of dismissal. Had the respondent workman not raised the industrial dispute, the claim of the respondent to challenge the order of dismissal would have become time barred, and it is the evil design of the petitioner management in while filing a miscellaneous case number 2 of 2021 before the industrial tribunal which is non-functional, and thereby preventing the respondent workman from agitating his independent case under section 2 capital A of Industrial Disputes Act. Right? Yes. आपका क्या stand है?
Lordship, my stand is that under section.
एक second. The learned counsel has relied upon a judgment passed by Honorable Andhra Pradesh High Court, reported in bracket 2005 bracket close 1 LLJ 980 within bracket 8P, and has referred to in paragraph and has relied upon paragraph 5 of the said judgment.
Lordship, one of the cases has been filed under section 10. It is just for the reference, and the another case, Lordship.
10 and 13. 10 and 13. Para 5 and 13.
One of the matters which were filed, it is just for the reference, Lordship, under section 10 of the Industrial Dispute Act. It can be whether the matter can be referred to the board or not, Lordship, or the Industrial Dispute, Lordship, Industrial Tribunal. And the another case is under section 32(3)(2)(b) of the Act, where they are seeking approval where termination has been already been made by the petitioner, Lordship. So there are two different cause of actions according to.
The learned counsel appearing on behalf of the state while opposing the prayer has submitted that the scope of jurisdiction under section 33(2)(b) of the Industrial Disputes Act and that of reference under section 10 of the Industrial Disputes Act are totally different. The petition filed by the petitioner under section 33(2)(b) is for the approval of the order of dismissal, and the reference under section 10 is challenging the order of dismissal.
No, Lordship, not challenging whether it can be referred or not, referred to the Industrial Tribunal or not.
No, वो तो reference तो हो गया है.
Yes, Lordship. But under section 10, whether the matter can be referred or not, that is the.
It has been referred.
Yes, Lordship.
It has already been referred.
Yes.
That is all. Anything else?
No.
Arguments concluded. If to date the judgment. कौन है पंकज? You take this judgment, this dictation at the earliest. इसको रख लीजिए. इनका इन पर्सन आपने अपीयरेंस मेमो फाइल करिए. आप नहीं फाइल करिएगा, इनसे खुद से करवाइए. इनका अपीयरेंस नहीं, खाली वर्कमैन का. नहीं, इसका कोई काम नहीं.
इसको रख लीजिए.
To date दीजिए ना कोई. चार्ट दिखाइए. डेट आपको मिल जाएगा. जजमेंट का डेट आएगा, उसमें बहस नहीं करना है, सीधे जजमेंट के लिए. ठीक है. चौदह 5 को आएगा जजमेंट के लिए. बोल दीजिए उनको. 14/5 को जजमेंट पर आएगा. चलिए नेक्स्ट वन.
Item 2, WPS 328 of 2023.
The person who asked for I was supposed to file a supplementary contract that we need to file but have served a copy to the other side. That was only in relation to whether what proceeding is being taken by the JPC. There are two parts in his prayer. One is in relation to granting of confidence. Previously, JPC has already refused. Now we are reconsidering it, as there were some documents were required from the Withdrawal University. They have sent it. Now the decision is pending, is still with us. So we have not
Mr.
taken it.
Counsel, you see, as per the counter affidavit filed by the
Lordship, there is the certificate.
as per the counter affidavit filed by JPSC earlier, they are reconsidering your claim, right? Then let them reconsider. This case need not be kept pending. I will just record the Agarwal Commission recommendation, right?
My lord, he has taken consent from me
For what?
For grant
Since counter was not filed, Your Lordship, this.
You see, the matter is very simple. As I
Yeah,
understand,
very simple.
it is
It's
under
simple.
active consideration of JPSC. We will fix a timeline. आप बोलिए कि 2 महीना 3 महीना में they will take a final call on that.
लीगल भी तो समय ले चुके हैं इसको
Earlier कहाँ से?
एक बार चांस दिया जाए
नहीं, they are considering it. They will consider it within a time frame. अरे समझ में नहीं.
Previously, Your Lordship, since he has already under litigation, thrice he has come down.
Thrice.
So, the second time is coming. Previously, also, since filed a writ petition, where decision was taken, where we refused the concurrence.
You refuse the concurrence. Now you are
Now we
reconsidering
yes,
it
as per the counter
because you want to figure out whether आपने MSc का सर्टिफिकेट भी नहीं लगाया आपने से.
Right, that was the
लगाया है आपने?
अब लगाया.
अब
भेज
लगाया.
दिया. अब आया.
इसमें तो रीट में तो नहीं है.
रीट में नहीं.
नहीं है. हम बहुत खोज रहे थे, हमको नहीं मिला.
नहीं,
एक
अब
एक
आ-
पन्ना पलट के देखो.
अब now we have received that.
So therefore you take a call. How much time do you need to complete?
Well, also, since there are 2 point prayers, one is in relation to the concurrence. Once we grant the recommended the concurrence, the university will notify. Thereafter, the university will send the proposal to us to consider on the point of promotion.
Okay.
And that is only 2 point. Once they send the proposal again, we will take again some time to finalize it. We'll take a decision on that also.
No. First is that you are seeking some information from Vinoba Bhave University.
That has come to us in
That has
relation
come
to
to us.
concurrence.
In relation to
Concurrence only.
Once the concurrence comes,
Yes, once we recommend for concurrence, they will notify it.
okay.
Once they notify it, they will be resending the proposal for promotion.
Okay.
Then again it will take some time.
All right.
Then after we'll take a decision.
That
So,
timeline also we can give.
yeah, that timeline.
Which heard the learned counsel for the parties. This writ petition has been filed for the following relief. The records of the case indicate that the petitioner had moved this court earlier in WPS number 2503 of 2019, seeking a direction upon the respondents to grant promotion to the post of reader with effect from 15/3/1995 and to the post of professor from 15/3/2003 with corresponding monetary benefits and interest. The said writ petition was disposed of to the committee. To the committee constituted in compliance of the judgment passed by this court in WPS number 3375 of 2016 and other analogous cases. Pursuant thereto, a final decision has been taken by the university at contained in annexure. It is not a. It is by the JPSC. A decision has been taken by JPSC, wherein it has been held that the petitioner had obtained the post-graduation degree on 15/3/1987, which is after the date of his appointment on 7/10/1985, and therefore at the time of appointment the petitioner was not having the requisite qualification, and consequently the concurrence for promotion was not granted.
I beg apology. Your Lordship, the university had taken decision which is annexure B of the show cause, starting from page 55. Pursuant to the order passed by this honorable court.
55.
Page number 55. Internal page 55. The show cause was filed by the university in the contempt proceeding, and the order is annexed.
At running page?
The running page 55.
Running page 55 is the show cause. 58 is the show cause.
Yeah, it's 55. In the SOCOS file with the university.
This is the decision of the university.
Pursuant to the order passed by the Supreme Court, the university took a decision. Last line was in relation to concurrence. Unless and until JPSC grant the concurrence, we cannot do. Thereafter, JPSC refused.
Okay, pursuant to the order passed by this court, the university has taken a decision on 16/6/2021 by holding that a teacher can be considered for promotion to the post of university professor when he is a reader/associate professor. The petitioner was working as assistant professor for which concurrence was still pending with JPSC. Hence, the prayer of the petitioner for promotion on the post of university professor under 8+8 years merit promotion scheme was not considered. This was sent to the JPSC?
Yes. Now, annexure 13 election.
Okay. Thereafter, the matter was sent to JPSC, and JPSC has passed the order as contained in
Memo number 4030.
Memo number 4030 dated 22/11/2022 by holding that at the time of appointment on 7/10/1985, the petitioner was not having higher second class
Yes. Higher second class.
post-graduation
Master.
degree, and he obtained such degree subsequently on 15/3/1987,
Yes.
and therefore the petitioner was not entitled for the appointment,
Concurrence to the appointment.
was not entitled for concurrence to the
concurrence.
appointment,
So we declined.
and consequently the
JPS is declined.
JPSC declined the concurrence
Yes.
regarding appointment of the petitioner. The learned counsel for the petitioner has referred to the recommendation of the Agarwal Commission and has submitted that as per the Agarwal Commission recommendation, the petitioner was appointed as lecturer in zoology by order dated 5th October 1985. On the date of appointment, he did not have higher second class post-graduation qualification, having secured 52.10 marks. He improved his qualification and obtained MSc degree with 63% marks on 15th March 1987, and he became eligible for consideration on 15th of March 1987. The learned counsel submits that the Agarwal Commission recommendation is in favor of the petitioner. The learned counsel, and accordingly the impugned order calls for interference. The learned counsel, appearing on behalf of respondents, has submitted that Jharkhand, that JPSC is reconsidering the matter of the petitioner, and for which appropriate letter dated 16/8/2023 has been issued
Yes.
to the University,
Yes.
calling for certain information regarding the MSc degree of the petitioner, and such information has already been received by JPSC. He submits that the matter being under active consideration of JPSC, and once an order is passed by JPSC, then it will be referred to the university, and the university will do the needful, notify the concurrence, and thereafter the matter will again be referred to JPSC for the purposes of consideration of promotion of the petitioner. After hearing the learned counsel for the parties and considering the totality of facts and circumstances of this case, this court is of the considered view that JPSC is revisiting its earlier decision, for which appropriate communication has been made by between JPSC and the university. The necessary information from the university has already been furnished to JPSC. The matter and accordingly the matter cannot remain indefinitely pending at the end of the respondents. In such circumstances, JPSC is directed to take a final call in connection with the claim of the petitioner regarding his approval of appointment within a period of 2 months from the date of communication of this order. And if the decision is found in favor of the petitioner, the decision should be a reasoned order. It should be communicated to the petitioner through speed post. If the decision is found in favor of the petitioner, then the university is also directed to do the needful within a period of 15 days from the date of receipt of communication from JPSC, and again refer the matter to JPSC for further decision with regard to the claim of promotion of the petitioner. If any pause, sorry, 3 weeks कर दीजिए. Upon receipt of communication from university, the JPSC shall do the needful within 15 days.
Lordship, since we have to recheck every each and paper,
Within a period of 4 weeks
Lordship.
from the date of communication from the university. This should be sufficient. ठीक है? This petition is accordingly dismissed. ये एक ले लीजिए. Supplementary counter affidavit of JPSC is taken out. अभी वो जजमेंट नहीं आया आपका वाला, यूनिवर्सिटी वाला एक तो चल रहा है, मिस्टर अतनु बनर्जी का नहीं आया ना?
नहीं.
इसीलिए अभी इसको डिसाइड नहीं किया. It is posted for judgment on some day.
Item 3, WPS 421 of 2023.
Yes, petitioner.
Pursuant to your Lordship direction, we have filed the counter affidavit of the chairman from managing director. And now the rejoinder has also been filed.
He has already been granted promotion.
Yes, he has already been granted promotion, your Lordship. That is the last annexure.
Now he has a grievance with regard to the date.
Yes, your Lordship, may kindly see the appointment letter for a moment, your Lordship. That is annexure B, page 22. The relevant question is 23. That is the appointment letter.
Yes.
Serial number 4 and 5. You will be treated as a full-time employee of the company and you may be posted anywhere in the company in connection with the company work. Number 5. During the service period, you may be transferred to any area project.
So therefore, he belongs to the one cadre.
They belong to one cadre, your Lordship, but your Lordship may kindly see the cadre scheme, your Lordship. That is implementation instruction 42, annexure G, page 31. That is to the NCWA 5. Relevant portion is page 32. serial 5 from the down, Your Lordship. The zone of promotion from technical and supervisory grade B will be area level.
Okay.
And from B to A at company level. Therefore, at that relevant time, he was posted at
Now
Madras
you see,
area.
initially he was not granted promotion.
Initially,
Now he has been granted promotion.
now he has been granted.
Now he has
promotion.
a grievance regarding the cut-off date. That is a different cause of action altogether.
Yes. Because at the vacancy has to be
Where is
seen
he?
at the area level.
Where is he?
वो चले गए।
He just left.
He just
left the company.
उनको कहीं बाहर जाना था मैडम।
He just informed in a
उनका
morning.
फ्लाइट था वो
अच्छा।
इसीलिए वो बोल के गए थे।
हाँ क्या चाहिए आपको? कब के लिए? Passover for the day means tomorrow.
नॉट टुडे कर दिया जाए, आफ्टर होली वेकेशन आएगा ये आ जाएंगे।
फाइल पढ़ने के बाद हमको इतना पेशेंस नहीं रहता. Counsel for the parties are present. Counsel for the petitioner prays for not today. As Mr. Atanul Banerjee, the arguing counsel, has left the court for some personal reasons. Post tomorrow.
कल भी वो आएंगे कि नहीं दिल्ली के बाद?
I do not know.
ये बोल के
रहे हैं
हमको
कल.
बोल के गए हैं, उसको कन्वीनियंटली एक दिन बात कर दिया जाएगा।
आप
हमको बोले
आपको बोल के गए.
अपना पर्सनल डिफिकल्टी बताए थे।
Day after tomorrow.
डे आफ्टर टुमारो।
Item 4, WPS 452 of 2023.
Yes, petitioner.
Your Ladyship, the counsel affidavit is in the process of filing, Your Ladyship. In this matter, I am appearing for the university, Your Lordship. State government is also a party,
So what do you want? Adjournment?
Your Lordship.
For what?
This direction upon us to file counter affidavit, Your Lordship. If the if Your Ladyship wants to hear the matter, the counter affidavit is ready. I have already served the copies to the opposite side.
Yes, we have just received a copy.
And our
You want to respond?
Yes, Suresh.
You are absolutely clueless whether you want to respond or you don't want to respond.
Your Ladyship, since it is not on record yet, and in 20 minutes, we kindly pass over this case for a few cases because my senior Mr. Suresh Gautam is
The
currently on
time
leave.
was granted only till 5/3/2024.
There were some personal difficulties at my end. I was facing some medical emergency with my father. I had received the statement of fact, but
WPS number 452 of 2023, the learned counsel for the respondent university files counter affidavit during the court proceedings, which is taken on record. The learned counsel for the petitioner prays for and is granted time till 4th of April 2024 to file a rejoinder, if any, to file a rejoinder to the counter affidavit. Post this case on 18th April. 18th नहीं होगा, 24th. The time? 24th April.
Item 5, WPS 501 of 2023.
Yes, petitioner.
Also, therefore, designating the post of compounder, dresser, vaccinator to the post of pharmacy. As per Government of India, circular dated 6 April 1987. Lordship, in the year.
You are seeking a mandamus.
Yes. I see. On the.
There is no order under challenge.
No. I am seeking mandamus on the annexure 6, Lordship. My respondent number 2.
Necessary steps have been taken by you.
Yes, Lordship. Annexure 3.
You just see para number 7.
Necessary steps have been taken in annexure 3, Lordship.
Annexure 3.
Annexure 3, page para 13, Lordship.
You consider his representation.
Your Ladyship,
And the other department, Lordship.
Your Ladyship, at the very outset, Your Ladyship, I tender my apology. We could not file the counter. I've been recently in panel with this.
Lordship, kindly see last.
I've been recently in panel with this organization. Your Ladyship, my statement of facts are ready. only a week's adjournment may be given to me. I
No.
need to bring something on record, Your Worship.
Nothing is
And-
required.
and it
He is
is-
just
as
seeking a
far as
mandamus.
This petitioner is, I raise a on the ground of maintainability also.
Yes. He had moved earlier?
No, my lords, his petition would perhaps lie before the Central Administrative Tribunal. Article 14, Section 14 of the. Your Ladyship may kindly see
No,
Section
no, it
14.
will go before Central Administrative.
Section 14 may kindly be perused for a minute, Your Ladyship.
Yes, yes, we are aware of that.
Civil post, my Ladyship.
Not maintainable. 226 ऐसे नहीं एक्सरसाइज कर सकते हैं, है ना? हमारे हाथ बंधे हुए हैं, आपका तो आर्गुमेंट बंधा हुआ नहीं. You are not bound by law. We are bound by law. You have a remedy under Central Administrative Tribunal. Yes. WPS number. No, हमको.
My representation may be decided. My humble submission is that. Can we dispose of?
देखिए ऐसा गलत तरीके से पावर एक्सरसाइज करके हम गलतियां नहीं करना चाहते, ठीक है? WPS number 501 of 2023. The learned counsel for the parties are present. The learned counsel for the respondents has submitted that the petitioner has an appropriate remedy before Central Administrative Tribunal, and therefore this writ petition may not be entertained. The fact that the petitioner has a remedy under Central Administrative Tribunal is not in dispute, even from the side of the petitioner during the course of argument. Considering the aforesaid objection raised by the respondents, this court is not inclined to entertain this writ petition. Accordingly, this writ petition is dismissed as not maintainable. However, the petitioner may avail his remedy before the Central Administrative Tribunal within a period of 1 month from now.
Without prejudice of the.
Sorry. आप समझे ही नहीं हम आपको क्या ऑर्डर दें. वहाँ लिमिटेशन का कहानी खत्म हो गया. हम कुछ नहीं लिखा है. 1 महीना में चले जाइए, आपका ऐसे ही एंटरटेन हो जाएगा.
Ladyship, only my appearance on behalf of the
हाँ,
canton.
आप नहीं दे दीजिए.
3 and 4, madam.
Item 6,
Obliged.
WPS 1291 of 2023.
Yes, petitioner.
Not today.
Not
आपकी माँ का तबीयत खराब है बाहर में.
किनकी माँ की तबीयत
अंजलि.
खराब? क्या मैटर?
The petitioner was appointed in Devgar in a park village, and now she is praying for regularization. Matter in short is that she was never appointed under a very sanctioned or a unsanctioned code or pursued to an advertisement.
There is a sanctioned post or there is
No,
no
there is
sanctioned?
no sanction for it. She has been deployed by the managing committee of the park. Now she is claiming her regularization based on that. There is no advertisement. There
कब
is
आएंगे?
no sanction. Absolutely nothing. There's absolutely no merit in this case.
You have filed your counter affidavit saying there is no sanctioned post also.
There is absolutely no
Have you
advertisement.
stated so in
Yes,
your
yes,
counter?
everything is stated. in it.
The learned counsel for the parties are present.
She is working under a private operator.
The petitioner seeks adjournment on the ground of personal difficulty of the arguing counsel, Mr. Anjani Kumar Verma. Counsel for the respondents has submitted that the petitioner is seeking regularization, although there is no sanctioned post
There is no
and the
sanctioned post.
petitioner was never appointed
Never appointed. There was this.
by the respondents. Rather, petitioner was working under the verbal instructions.
She was taken up by the private operators of the park, my lords.
She was the petitioner was employed under the instructions of the private players in the park.
Private operators of a park, my lords. There's a park
Private
in Devgar.
operators of the park.
Yes, my lords. And she was not paid any salary. She was only an honorarium.
Who paid it?
Private contractors, my lords.
And the petitioner was never paid any salary from the respondents. rather she was being paid honorarium by the private operator of the park. Posed this case on 4th of March under the heading of final dismissal. Sorry?
4th of April.
4th April. मार्च में है
उनका भी नाम लिखना दोनों
4 तारीख को उस दिन टाइम मत मांगिएगा मिस्टर काउंसिल उस दिन टाइम नहीं
Item 7, WPS 3024 of 2023.
petitioner yes what is it
The list of dates written argument and judgments.
do I have a right to seek adjournment ये बहुत contested matter है छुट्टी के पहले नहीं थोड़ा सा कर पाएंगे आप तैयारी कर ली हैं judge also has a right to seek adjournment isn't it this is yours
Yes.
आपका this
List
is
of
yours
dates.
list of dates
List of dates, written argument and judgments.
list of dates written arguments and
Judgments, two of the judgments.
this one
Yes, sir.
these two
These two.
इसको tag कर and this is yours and the bunch is
Bunch
yours
is there and 2006 regulation is also there. The, yes, that is there.
this I may tag with this आज छोड़ते हैं इसको आज नहीं थोड़ा सा पढ़ना पड़ेगा this is a very different kind of a matter I need to study a bit on this learned counsel for the parties are present learned counsel the petitioner has submitted his written list of dates and written notes of arguments and 2 judgments in support of his case दोनों judgment उसके साथ है citation state you have filed anything separately the learned counter filed
That also we haven't filed out, Your Ladyship.
you have not filed a counter right?
Actually, not Your
Counter
Ladyship.
they have
Counter is filed.
The learned counsel for the state has submitted that state would rely upon the counter affidavit. The learned amicus has also filed written notes with copy to the you have served copy
Yes,
to the
Yeah, I've also served the copy.
state को copy served with copy to the state and has also filed compilation of judgment and also circular dated 2/6/2006. You provide them this copy also, this circular. Pose this case for, I will just fix a date here. Twenty-ninth April at 2:15. 29th April at 2:15. ये फाइल हमको करके और याद दिलाने का है 2 दिन पहले. You can do one more thing. You give your soft copies of your written submissions for them. Right?
Orders 25 item 8, WPS 4984 of 2023.
I seek the court's kind permission to withdraw this petition with liberty to approach the appropriate forum.
Which is the appropriate forum?
Your Ladyship, the writ to be filed before the Odisha High Court since the jurisdiction arises in
WPS number 4984 of 2023. counsel for the parties are present. The learned counsel for the petitioner at the outset seeks permission to withdraw this petition to approach appropriate High Court. She submits that the cause of action of the present case does not arise within the jurisdiction of this court. Any objection?
No.
Learned counsel for the respondent has no objection to the prayer made. Accordingly, the petition is dismissed as withdrawn. However, liberty is reserved with the petitioner to take remedies as may be permissible under law.
साइन कर दीजिए.
Item 9, WPS
Prayer quote कर दीजिए.
688 of 6 of 2023.
Yes, petition.
Lordship, on last occasion, Lordship had directed to counter equity statement. You can see last occasion. Para 7.
They have not filed their counter affidavit.
Learned counsel for the respondent directed to seek instruction and file a seniority is prepared in terms of class 15(1), and if the position of the found senior to the.
My lords, I was seeking a short indulgence, my lords, in this case, so that we can file an affidavit. My lords, the officers have come; they are filing a IA petition, time petition, my lords. 3 weeks may be given. We'll be filing the same.
File that IA.
It's on the post.
You come at 2:15. I'll adjourn.
Yes.
You don't worry. I'll adjourn.
Give them the
तीनों एक साथ है. 3 matters. तीनों matters एक साथ.
Fresh filing.
सप्लीमेंट्री किसका था?
पास हुआ है.
पास ओवर कॉल करिए क्योंकि फ्रेश फाइलिंग में अभी देरी है.
पास हुआ.
Passover case from supplementary
पास
list.
ओवर का भी तो हमने कोई टाइम दिए थे ना. 12:30. अच्छा वो कॉल करिए. फ्रेश फाइलिंग के कुछ मैटर्स में काउंटर एफिडेविट फाइल करना है. उसके लिए तो किसी पिटिशनर की जरूरत नहीं होगी. ठीक है, कॉल करिए सर.
For case filing item 12, WPS 75 of 2023.
The counter will be not required in this case because I seek permission to withdraw this application. Reason being, my lord, that my lord has already decided one of these cases while sitting in a division bench. That order, my lord, saying this order. The matter relates to caste certificate, local residence certificate in a teacher's examination. My lord.
You can simplicity withdraw.
But I am only submitting my lord, this order may be referred.
I will not refer anything because I am not inclined because you have used that caste certificate for your appointment.
Yes, I have used.
So once you use a caste certificate, you want a rectification.
Yes.
I will not permit that.
Then will you see?
WPS number 75 of 2023. The learned counsel for the petitioner seeks permission to withdraw this petition. Permission is accorded. This petition is dismissed as withdrawn.
साइन कर दीजिए.
साइन कराइए. प्रेयर कोट करिए.
Item 13, WPS 77 of 2023.
I want to time for filing the joinder.
WPS number 77 of 2023. The learned counsel for the petitioner prays for and is granted time till 4th of April 2024 to file a rejoinder to the counter affidavit. Oppose this case under the heading the heading for admission on 10th of April.
Item 14, WPS 185 of 2023.
Good. You have filed your counter.
Yes, sir.
Let them file a rejoinder. A counter affidavit has been filed in the present case. The petitioner may file the rejoinder, if so advised, by 4th of April. Pose this case under the heading for admission on 10th of April.
Item 15, WPS 306 of 2023.
Although, as per the statutory documents, this petitioner is a legally wedded wife, adjournment, printed, and section 1 series. These are
Kindly read your prayer.
prayer names. That was 8 minutes. The respondent number 4,
एक एक करके prayer पढ़िए.
who is the husband.
आप prayer पढ़िए ना.
Prayer numbers.
हाँ क्या क्या
The
relief
action
हम आपको
upon the
दे सकते हैं.
respondent BCCL authorities as a whole to pay half of the salary as well as the entire postal benefits to the petitioner, being first legally wedded wife as against the service of her husband. Dhanpat Mahato, respondent number 4, is presently posted as pump operator in the Western Jharia area, AHQ Swelso.
Please hold on.
Plus,
You are seeking half salary
half salary
as
plus,
maintenance.
plus legally wedded wife not paying anything.
तो maintenance होगा ना 125.
Maintenance plus, I will say that since they are the state within the meaning of it, they have called us. We have filed a representation. They called us.
अच्छा ठीक है हम समझ गए.
They did not pass.
125 में ऐसा कोई लॉ है कि सरकारी कर्मचारी के खिलाफ में 125 मेंटेनेबल नहीं है?
Let's further prayers are there.
Okay,
In the declaration
next
of the
prayer.
it is what
Kindly-
interlinked millers.
Yes.
To declare and hold that the respondent number 5 is the illegally wedded wife. She has no legal right to get any amount out of the
ये
post-retirement
डिक्लेरेशन
benefits.
226 में होगा?
Pardon millers.
ये डिक्लेरेशन 226 में होगा?
Wife legally नहीं होगी. Records है, हम दिखा देंगे.
रिकॉर्ड से हम लोग नहीं डिसाइड कर सकते हैं कौन फर्स्ट वाइफ है कौन सेकंड वाइफ है, क्योंकि रिकॉर्ड में डिक्लेरेशन फर्स्ट वाइफ और सेकंड वाइफ का नहीं
है, इसमें है, हम दिखा
दे आर नॉट अ सिग्नेटरी टू दैट रिकॉर्ड. इट इज अ सेल्फ डिक्लेरेशन ऑफ द एम्प्लॉई.
They are the counter signature of the CCL authorities.
All right. CCL authority will decide whether a lady is first wife or second wife.
What I beg to humbly
Okay, I have understood. What is the next prayer?
For considerable for direction of the respondents to ensure 100% provident fund amount, gratuity as well as the pension to the petitioner in place of her husband, who having solemnized second marriage is an offender of law and deserves to be suitably treated as such by the employer BCCL. Consequently, for restraining the respondent BCCL authority as a whole not to release any amount if the respondent's second wife out of post-retirement benefits of her so-called husband, namely Dhanpat Mahato, as she is not released. But kindly see only one document. Whether it is tenable in
Post-retirement benefits is being released in favor of the ex-employee or it is being released in the name of wife?
As per the nomination, wife also.
Nomination is separate thing.
Only page 21.
The husband is alive?
Yes. Now she is retired.
He is retired but he is alive.
He is
दुनिया से
alive,
retired.
yes. But he is
post-retirement benefit किसको मिलता है?
Post-retirement benefit मिलता है उनको. But that does not mean that he will part with the second wife. Page 21 खाली देख लिया जाओ बस. इनका अपना document है. How can they must countenance these things? Page 21. बाकी जितना शुरू से declaration है सब में मेरा नाम है सिर्फ as a wife. Right from annexure 1, page 16. Wife is only Lukni Devi, then 3 siblings are there out of this first wedlock. Page 16. Then page 17, only Lukni Devi is the declaratory wife. Then we are only on the issue that you being in a state authority cannot countenance these illegalities. And then page 21 kindly see. They say Lukni Devi first wife and Urmila Devi second wife. They do not take any action. What they now say, when we approach them, they say proof of evidence of your first marriage. Can you see there later, annexure page 29. I am on this page 29. When we file an objection that he is not paying anything, not taking any care of mine, then they issued one letter to me. Pursuant to annexure 3, 4, and 5, their representations to the competent authority, they took cognizance of this issue. They called me and they said what? In page 29 minutes, they are not deciding, they are not passing any order over it. They could have passed any order, whatever may be in the way. I appeared and filed a representation and reply annexure 7. So only I am saying, they say what? Others, आपका अपना पक्ष रखने के लिए सभी साक्ष्य और दस्तावेज
What
के
is the
साथ
date of retirement?
date of retirement was 18 months was the left out from the date of this representation. So I think he retired in this December 2023. Exact date I don't know
But during his service period, some allegation was made that there is a second wife existing. But no proceeding was initiated against him.
In spite of this declaration, page 21, which is species, even if it is a declaration, they could have taken the action over it. They are model employer, they cannot continue this. Now what they are saying?
Now after your husband's retirement, they will initiate a departmental proceeding against him.
That at the time when it was filed, January 23. I have no contact with the client for up to date give me only 1 day time. Or I will file a representation first.
No representation.
This next year
WPS number 306 of
next year 6 has not been acted upon till date.
WPS number 306 of
Passing a
2020.
to do the complete justice between the parties.
The learned counsel for the parties are present. District petition has been filed for the following relief. With regard to prayer number 1 within bracket A of the writ petition, this court is of the considered view that petitioner is primarily claiming maintenance by asking for half of the salary as well as entire post-retirement benefits and claiming to be the first legally wedded wife. This court is of the view that such relief, this court is not inclined to grant such relief to the petitioner in view of the fact that the petitioner has an appropriate remedy under the provisions of section 125 of CRPC. So far as prayer made in 1 within bracket B is concerned, this court is not inclined to give any such declaration as to whether the petitioner or the respondent number 5 is the legally wedded wife. However, it has been pointed out by the petitioner at page number 21 of the writ petition that as per the declaration of the ex-employee, the petitioner is the first wife. So far as prayer made in paragraph 1 within bracket C is concerned, it has been alleged by the petitioner that the husband of the petitioner is an offender of law and deserves to be suitably treated by the respondent as model employer. This court is of the view that if any person has solemnized second marriage during the lifetime of the during the lifetime of first wife, then also the person has an appropriate remedy in law, and therefore this court is not inclined to grant any relief in terms of prayer 1 within bracket C of the petition. The fact remains that it is further not in dispute that the respondent husband has now attained the age of superannuation. However, it has not been brought on record as to whether any proceedings was initiated by respondent company against the husband while he was in service with regard to allegation of second marriage. The relief as prayed for in paragraph D is correlated to the relief at para 1A, and therefore this court is not inclined to such relief. This court in totality finds that the prayer made in this petition is not maintainable. Accordingly, this petition is dismissed as not maintainable. The petitioner, if so advised, may have remedy as may be permissible under law.
this annexure 6, they have called me, Manas.
Sorry?
They have called me for to produce the evidence.
I do not, you go and do whatever. I simply say that I am not going to give any declaration. That is why I have said that we are not aware whether any proceeding was initiated or not initiated.
So, what I am begging you not to that annexure 6, they have called and they have not decided this.
We do not know. See.
Item 16, WPS 392 of the 2023.
You filed your representation.
But we have already filed the representation.
Before whom have you filed? We will expedite it.
That is picture 3 number just earlier.
Before whom? Before 2? Respond number 2? Secretary, Road Construction Department. Also, for the petitioner is present, this petition has been filed for the following relief. The counsel for the petitioner has submitted that the Road Construction Department, Government of Jharkhand, has granted grade pay of rupees 4,800 with effect from 1/9/2008 to the petitioner after his retirement in the year 2018, but the financial benefit out of the same has not been paid to the petitioner. Consequently, the petitioner had filed representation before the respondent number 2, but no decision has been taken so far. Considering no counter affidavit as such has been filed in the present case, and the petitioner is seeking a mandamus from this court on account of the fact that the grievance of the petitioner has not yet been redressed in spite of filing representation. Accordingly, this court is of the view that the matter can be expedited by directing the petitioner, by directing the respondent number 2 to consider the grievance of the petitioner and pass a speaking order in accordance with law. Accordingly, this writ petition is disposed of, enabling the petitioner to approach respondent number 2 by filing a fresh representation along with a copy of this writ record and a copy of this order within a period of 1 month from today. Upon filing of such, and also supporting documents. Upon filing of such representation, the respondent number 2 is directed to grant an opportunity of hearing to the petitioner and pass a reasoned order with regard to the entitlement of the petitioner. The reasoned order be communicated within a period of 4 weeks from the date of representation. The reasoned order be communicated to the petitioner through speed post. It is further directed that if the petitioner is found entitled to any monetary benefit out of the reasoned order, the respondent number 2 shall take appropriate steps so that the monetary benefit is also remitted to the petitioner within a period of 3 months from the date of the reasoned order. This petition is accordingly disposed of. It is for the respondent number 2 to pass appropriate reasoned order in accordance with the applicable rules, guidelines, etc., as may be applicable to the petitioner.
Item 17, WPS 617 of the 2023.
Yes. Compassionate appointment.
No. Yes, compassionate.
What is the date of death?
Annexure 4, page 3.
Date of death, bata.
Date of death is my lord. 1989.
10/9/19. आपका कितना उम्र था इस समय?
It's now my lord. I have to prepare. Is 43.
अभी तो प्रेजेंट का एज है ना, उस समय कितना उम्र था? 89 में. 89 का डेथ में अभी आपको कॉम्पैशनेट अपॉइंटमेंट चाहिए, जनरेशन बदल गया 2। आजकल 10 साल में जनरेशन बदल जाता है। If you meet people 10 years before you and 10 years after you, you'll feel that there is a change in generation. WPS number 617 of 2023. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The counsel for the records of the case indicate that the petitioner claims to be the son of ex-employee, namely late Hemlal Soren, who had expired as back as on 10/9/1989.
कनेक्शन कोड कम से कम देख लिया जाए। He was not the employee. Rest गलत है।
अच्छा, कौन थे एम्प्लॉई?
एम्प्लॉई नहीं थे।
अच्छा, he was not the employee. He did not join.
He did not join.
I forgot. घर में पढ़े थे, भूल गए। एक सेकंड, फिर से please take it. Counsel for the petitioner has submitted that the petitioner is claiming compassionate appointment as his father expired on 10/9/1989. The impugned order reflects however, he had expired prior to joining the service, right? Considering the impugned order and the fact that the father of the petitioner had expired way back in 1989, this court is not inclined to grant the relief as prayed for in this petition, which is accordingly dismissed.
One thing serial number 40 is supplementary में ये हम लोग का नोटिस था कि ये मुझे सुना जाएगा।
हम आपके उसमें रिजॉइंडर के लिए कर दिए। नोबडी हम लिखे ही नहीं, हम जान रहे हैं आप आएंगे, उसी में नोबडी नहीं लिखे, हमको पता नहीं रहे। हमको पता है आप रिजॉइंडर फाइल करेंगे, करेंगे ना? नहीं करेंगे तो सुन लेते हैं।
नहीं करेंगे, उसका और कुछ डेट दे देते, आगे बढ़ा देते तो हम चाह रहे थे।
हम तो अब डेट दे दिए।
वो बिफोर द सुप्रीम कोर्ट सिमिलर मैटर में
कोई बात नहीं, हम आपको रिजॉइंडर फाइल करने के लिए टाइम दिए, आप रिजॉइंडर फाइल करें।
At a meeting WPS 633 of 2023.
Annexure 6, page 25 is under challenge, by which application of compassionate amendment of the petition has been rejected.
What is the date of death?
17/7/2017.
17/7/2017.
At that time I was 16
Your father.
years. And the doctor.
Your father had expired. When did you file the application?
2018. She was 16 years old.
वो अपने परेशान हैं, आप क्यों परेशान हो? और परेशान हैं?
On 5/12/2017 I have given the representation.
5/12/2017. Where is that application?
Annexure 5, page 22.
क्या है आपका, पढ़िए। यस।
सादर अनुरोध है कि मेरे पिता स्वर्गीय पिता सोनवा रविदास ग्राम सोनसो जो डोरी के खास कुलेरी का पीआरटीआर के मजदूर थे तथा वर्तमान में रीजनल अस्पताल डोरी में कार्यरत थे। इनकी मृत्यु दिनांक 17/7/2017 को एक सड़क दुर्घटना में हो गई। उनके परिवार में मैं उनकी एकमात्र पुत्री हूँ तथा दादी परवा देवी है। मैं वर्तमान में अपने नाना के घर में रहकर पढ़ाई कर रही हूँ। मेरे स्वर्गीय पिता सोनवा दास धनबाद कोर्ट में मुझे खर्च के लिए हर माह राशि देने का वायदा किए थे, लेकिन आज तक मुझे एक पैसा उनसे प्राप्त नहीं हुआ है। अब उनकी मृत्यु के उपरांत उनकी सारी संपत्ति पर मेरा अधिकार होना है। अतः श्रीमान से साधारण अनुरोध है मेरे पिता स्वर्गीय सोनवा रविदास के मृत्यु उपरांत उनकी जगह पर नौकरी तथा कंपनी का सारा बकाया भुगतान मेरे नाम से होना चाहिए। मैं अपना आधार कार्ड, मुखिया द्वारा निर्गत प्रमाण पत्र तथा विद्यालय परित्याग प्रमाण पत्र, इन सभी पत्रों की छायाप्रति इस साथ में संलग्न कर रही हूँ, इनके आधार पर उचित कार्रवाई कीजिए। And again, leadership, on 28/8/2018, I have given a representation, further representation, page 23.
Why have they rejected it?
On
This
the-
particular representation is not referring to your earlier representation. मेरी उम्र दिनांक 6/2/20 को 18 वर्ष पूरी हो चुकी है. Right?
Yes.
You attained the age of majority on 6/2/20.
After that, I have also given the representation, but that is pending.
No. You don't need to go to that.
Yes.
Are you entitled for compassionate appointment?
Yes, Rashid. I have
Whenever
not-
you attain majority.
Yes, Rashid. That is
By
there
what?
in the NCWA.
बताइए कहाँ?
NCWA में है।
कहाँ है बताइए भाई. NCW
Minor-
में आप बोल रहे हैं कि माइनर को दे देना है compassionate
नहीं,
appointment.
minor को नहीं देना।
तो क्या
After
देना?
completion of 18 years, the appointment can be.
Where show us something.
NCWA के रूल में है Rashid.
तो बताएंगे ना आप रूल.
9.3.0 या
पढ़िए रूल पढ़िए.
Rule I don't have the copy.
तो आप क्या करें?
इसको पास हुआ कर दिया हम निकाल दिया।
लेके.
Can I make one? Live roster is there, but Your Lordship, the problem is, Your Lordship, kindly have a look. आपका नाम मृत कर्मचारी के आधिकारिक रिकॉर्ड में कहीं भी मौजूद नहीं है. तो let me file the counter affidavit, Your Lordship, that what is the situation, what she has to produce, or what is the difficulty that she has not been provided the compassion, whether she is entitled, whether she
There is an order.
Yes, Annexure 6. We kindly have a
Page
look at that.
25.
Page 25. On what ground at that time it was rejected in the year 2019 itself. First is your ladyship, आपका नाम मृत कर्मचारी के आधिकारिक रिकॉर्ड में कहीं भी मौजूद नहीं है.
What is the name of the ex-employee?
He is स्वर्गीय सोनवा रविदास. So I have to file counter whether she is, first thing is whether she is entitled.
Learned counsel for the parties are present. लाइव रोस्टर में महिला को रख सकते हैं.
नहीं, NCWA में कहता है कि daughter का there is no provision of daughter, but to be very fair, several judgments have come apart. The provision is still there, but still some judgments have come of this court and Supreme Court also that even if the provision is not there, that is not correct. Daughter should also be given, but that is there. But her name is nowhere in the service record except. So I will have to file
Just a
counter.
moment. The learned
How
counsel
she
for the
entitled.
parties are present. While referring to Annexure 6 of the writ petition, the claim of compassionate appointment of the petitioner has been rejected by mentioning that the name of the petitioner did not figure in the records of the respondent company,
Service.
and at the time of application on 28/2/2018, the age of the petitioner was 18 years.
At that time she was 16 years when it was rejected.
And there is no provision for giving appointment to keep a lady in live roster under NCWA. As per Annexure 4 of the writ petition, which is a certificate issued by Jharkhand Academic Council with regard to the petitioner, the date of birth has been shown as 6/2/2002 and the name of the father of the petitioner has been shown as Sonua Ravidas. It is not in dispute that the name of ex-employee is Sonua Ravidas. The learned counsel for the respondents is directed to seek instruction and file a counter affidavit in this case, taking into consideration the aforesaid facts. Let the counter affidavit be filed by 4th. 4 तारीख छुट्टी आपके ऑफिस से छुट्टी में है? Are they on holiday? By 10th April. Compassionate appointment है ना, ज़्यादा लंबा टाइम नहीं दे सकते. नहीं, एक चीज़ लिखिएगा. The counsel for the petitioner has submitted that no distinction can be made between a girl child and a boy child, and petitioner is entitled to be kept in live roster. The educational certificate granted by Jack reflects the name of the father of the petitioner, which is an undisputed document.
That has also to be seen whether she is married and her husband is capable of both things.
18 साल के पहले शादी हो गया क्या?
नहीं, अभी तो वो 18 से ज़्यादा की हो गई ना, अभी तो वो 22 साल की हो गई.
उसका राइट तो क्रिस्टलाइज हो गया पहले ही. बाद में ऐसा है क्या लॉ में कि अगर कॉम्पैशनेट अपॉइंटमेंट मिल जाएगा तो जिंदगी भर शादी नहीं करना है? कर ही सकती है ना. ऐसा तो लॉ नहीं बनाए हैं आप लोग.
जिस समय वो देना है उस समय वो हार्नेस वाला
वो तो हम लोग डिसाइड करेंगे. Counter affidavit filed by 10th April, rejoinder by 19th, post on 22nd April under the heading for final disposal.
Passover case from supplementary list. Item 2, WPS 129 of the controversy along item 3 to 5.
There are 3 writ petitions altogether. This is the first writ petition, 129/2013.
Just a moment, let me note down. 129/2013.
The counter affidavit.
How many writ petitioners?
In this case, 7 writ petitioners.
7 writ petitioners.
And in this case, I have filed the rejoinder also.
थोड़ा सा फाउंडेशनल फैक्ट्स हमको लेने दीजिए. सबका इनिशियल डेट ऑफ अपॉइंटमेंट इज द सेम. बताइए, डेट बताइए.
This is 27/12/12. 27/12/2012.
12/12. Their service renewed from time to time. सबका
renew.
What is the last date of renewal?
सबका थोड़ा सा डिफरेंस है.
Lekin everybody's case was renewed from time to time.
Time to time.
Initial was 1 year.
1 year. It was renewed. Sometime in advance, sometime post facto. In the first case,
Just a moment. What is the last date of renewal?
Last date of renewal in the first case is 13/12/2022.
2022.
By
Expiring on?
Expiring on different dates. This is with respect to somebody 9/2/2023, somebody 27/12/2022.
It is by one document?
It is by one document.
Where is that document?
Annexure 15. First case, page 51.
Page 51. Page 51. Just a moment. And the outer date has expired as of now. As per page 51.
With respect to these persons, during pendency of this case, after this interim order was passed on 14/2. 14/2/2023.
2023.
After the filing order, this was filed on the scenario account of one word. अंतिम रूप से अवधि विस्तारित किया जाता है. Was find in column 4 अंतिम रूप से. This was the situation where they came to this court and having completed more than 10 years. In all
कहाँ पे column?
जो जहाँ स्टार्ट होता है चार्ट, उसके जस्ट ऊपर जो ये खत्म हो रहा है हिंदी में लिखा हुआ जो है, भूमि संरक्षण स्वयं जहाँ कॉलम 4 के अनुसार अंतिम रूप से अवधि विस्तारित किया जाता है. This अंतिम word was the main cause of action. So earlier all the extension was this word was not there. And this came on the face of the fact, that when the director, who is the appointing authority, himself has made a recommendation in 2015 itself, that since they were appointed as against the duly sanctioned post, after after the due examination, interview, etc., merit list, following the all reservation roster, etc., they should be regularized. It was written to the secretary by the director himself, who is the appointing authority.
When is that document?
This is an extra 10 words. Kindly have a pleasure of that. Page 44. Complete recital is here also. May I have pleasure of reading it also?
Yes.
कृषक स्वयं सरकार के सचिव पशुपालन सहकारिता विभाग झारखंड रांची झारखंड कृषि अधीनस्थ सेवा कोटि 2 अधीनस्थ अस्थायी सृजित पद कनीय अभियंता कृषि अभियंत्रण की नियुक्ति हेतु संविदा पर कार्यरत कनीय अभियंता को विशेष नियमितीकरण नियमावली बनाने के संबंध में भूमि निदेशालय स्वयं आधारित कनीय अभियंताओं का सम्मिलित आवेदन दिनांक 0 अभियुक्त उपयुक्त विषय प्रासंगिक आवेदन संलग्न सभी अनुलग्न मूल रूप में इस पत्र के साथ संलग्न करते आवश्यक कार्रवाई हेतु अग्रसारित किया जाता है. यहाँ उल्लेखनीय है कि सरकार के स्तर पर प्रशासनिक पदवर्ग समिति के लिए संविदा पर सेवा प्राप्ति हेतु वित्त विभाग झारखंड रांची को संलेख उपलब्ध कराया गया, जिसके लिए प्रशासनिक पदवर्ग समिति की दिनांक 29/6/12 के 3:30 बजे अपराह्न में मुख्य सचिव झारखंड रांची के स्थान में हुई बैठक में कृषि एवं गन्ना विकास विभाग के अंतर्गत भूमि संरक्षण निदेशालय के अधीन स्वीकृत 22 कनीय अभियंता के पदों पर संविदा में आधार पर सेवा प्राप्त करने के लिए स्वीकृति प्रदान की गई. तत्पश्चात संविदा आधारित कनीय अभियंता कृषि अभियंत्रण की नियुक्ति संबंधी नियमित नियुक्ति की तरह ही प्रक्रियाओं का अनुपालन किया गया, जैसे कनीय अभियंता के स्वीकृत 22 पदों का रोस्टर क्लियरेंस करना, विज्ञापन प्रकाशित करना, स्क्रीनिंग समिति का गठन कर उम्मीदवारों का रोस्टर के अनुसार चयन करना इत्यादि. भूमि संरक्षण निदेशालय झारखंड रांची के कार्यालय आदेश ज्ञापक सचिव सचिव एवं सचिव सचिव द्वारा क्रमशः 2014-15 तक संविदा की अवधि विस्तारित की जा चुकी है. In spite of this, they continued keeping this hanging sword over our head and only extending 1 year, sometimes and most of the time post facto. Expired tenure, we were never removed. We continued for years together, and after 1 year, 2 years on exploitative terms, when they started running, salary was stopped, etc. They approached the secretary, director, sometimes the dharna, etc. Then post facto extension and salary was paid. But this is the gist of the admission made by none else than the appointing authority, who is the issuing authority.
Who is your appointing authority?
This director
under the service rules.
Under the service rule also. This for junior engineer, this director soil conservation because it is posted under the directorate of soil conservation.
Director of
soil conservation.
Bhumi Sanrakshan, soil conservation.
In agriculture department, there happens to be 3 directorates. One agriculture, another is horticulture, and this is soil conservation. So there are 3 directors under the agriculture department. He is the one of the wing of the agriculture department, and these are the post sanctioned under the directorate of soil conservation. So this letter encompasses, at least to the extent that our entry is not a backdoor entry. We are not an unqualified person. We were selected after following the regular appointment process. All that has been done.
Please hold on.
My lords.
The learned counsel for the petitioner has submitted that the petitioners were appointed after following due procedure against sanctioned vacant post. Though the appointment was on contractual basis, initial period was for 1 year, which was renewed from time to time, and most of the time the renewal was after the last date. The learned counsel has submitted that the cause of action arose to move this court in view of Annexure 15 dated 13/12/2022, wherein the extension was granted by way of last chance, meaning thereby that no further extension would be granted thereafter. The Learned Counsel has referred to Annexure 10 dated 25/8/2015 to submit that the appointing authority, that is the Director Soil Conservation, Jharkhand Ranchi, had himself recommended to the Secretary of the Agriculture and Animal Husbandry and Cooperative Department, State of Jharkhand, clearly mentioning that all the procedure, including the reservation roster, etc., were followed at the time of the appointment of the petitioners, and he has recommended that under such circumstances their services were to be regularized.
Now notice thereafter what happened, not only this, by Annexure 11, value appraiser page 45. Our payment was also transposed in pay scale. It was earlier a consolidated one. It was fixed according to their scale. So all trapping of regular employee, ad hoc in nomenclature, regular in
Council
nature.
has also submitted that though at the time of appointment, the amount payable to the petitioners was consolidated amount, but by issuance of letter dated 6/10/2015 as contained in Annexure 11, the petitioners were also granted an appropriate pay scale. He submits that the action of the respondents indicate that the petitioners were throughout treated as regular employee, though initially appointed on contract basis and renewed from time to time.
Now, Lord Lordship, we were transferred also. This Annexure 12 will indicate with respect to one person to the next. This man was transferred from Ranchi to Lohardaga. These all are indicates
The
that
council has also submitted that even the petitioners were subject to transfer, and one such sample order of transfer with regard to one of the petitioner has been annexed at Annexure 12, which is a transfer order from किसका है? From Ranchi to
Lohardaga to Ranchi.
From Lohardaga to Ranchi, which is dated 23/6/2016.
Now, thereafter the extension letters I have annexed Lordship, Annexure 13. This is also post facto, Annexure 14, then 15 minutes that my lords have just seen. So, what does it show, my lords? That from the beginning itself, they were subjected under the exploitative terms, although they were duly qualified, appointed after due procedure. So, only nomenclature was ad hoc or the contractual. It was regular in nature, ad hoc in nomenclature.
The Learned Counsel submits that the appointment of the petitioners for all practical purposes were regular in nature, and for the purposes of nomenclature it was contractual.
And therefore, it was totally exploitative term. The Supreme Court has. Therefore, I was relying upon Kamal Prasad's judgment, leaving apart others, because that case suits most closer to the fact of this present case. Doctrine of precedents over the president says the cases which is closer to the fact of your case will apply better. There are hundreds of cases on regulation, but I have labored hard to filter out what suits to my case closer to your. So this is the thing. Then after this, what happened? This court passed the order, interim order, considering all these facts that if they are working, they will not be removed. With respect to all these persons, they, in spite of the order of passed on 14/2/2023, the director passed an order of loss so-called upon the field officials as to why you people are taking work in spite of expiry of contract in somebody in January 23. somebody, as per this section 15, my lords will find one of the person last that was expiring is with respect to my lords Uday Kant Yadav, which is my lords 23/4/23. This is serial number lordship 9.
Yes.
In spite of this, my lords, when this in the next case, now my lords kindly have pleasure of the second repetition for my lords kind pleasure, how they are behaving in this case.
How many total persons were appointed?
Plus 12 persons.
Only 12 persons?
Persons, several below, but several left out, only 12 persons are left out. 22 persons were appointed, several persons joined another service below or left out. 12 persons are before my lords altogether through three repetitions. 7, 4 and 1. It was this first repetition that my lord was considering. 7 persons are there, lordship. In Bholanath is the alone Millers, singular. This is WPS 2597 of 2023.
2597 of
2023.
Yes.
He is single person Millers.
What was his letter of extension?
Yes, Millers, kindly see. Another person in Millers repetition before my lords is 3621.
So first you complete Bolana?
Bhola. Let us have the Bhola Millers first. What happened, your lordship, in this case? Bhola Millers came to this court on 9/5/2023. The repetition was filed.
Show me the letter of extension.
Gratefulness. All the documents are same, Millers. One document only varies, that is annexure 17, page 57. This will show, my lords, that this is later dated 28/2/2023. Page 57, my lords.
Yes, page 57.
Grateful, my lords. This will show in what way they were, my lords, treating these persons. This is the order dated 28 February 2023, by which my extension has been granted with retrospective effect for 2 financial years, 18/1/21 to 17/1/2022 and 18/1/2022 to 17/1/2023. Why I am emphasizing for my lord's kind's consideration that this letter of extension was in totally rendered sham arrangement. It has got no meaning in the FLO, because in spite of expiry of the contract periods, we were never stopped. We were altogether being allowed to discharge our duty, because it is an indispensable requirement for the estate, because there is no junior in the department.
Okay, with respect to WPS number 2597 of 2023, the learned counsel for the petitioner has referred to Annexure 17, which is a letter of extension of the contractual employment of the petitioner, which is dated 23/2/2023, and he submits that the extension was post facto for the period from 18/1/2021 to 17/1/2022 and 18/1/2022 to 17/1/2023. The learned counsel submits that this letter itself indicates that the petitioner was continuing to work irrespective of any letter of extension, and therefore the very issuance of letter of extension was completely meaningless. The petitioner was a regular employee for all practical purposes.
And this has been recorded at page 56. Just lordship will turn back the letter of recommendation for extension, and the field official, who is the district soil conservation officer, under whom we are working in respective districts, what the right while been making an extension. Kindly see the last column, page 56. It starts from page 55, annexure 16/1.
The learned counsel, while referring to page 56, which is a letter dated 16/3/2023, has submitted that as per the said document, there was a need for extension as there were no junior engineers in the department.
So they are catering the need of the state, my lords. They are taking our job. Only nomenclature is contract with their job. Rest is things. Therefore, in these circumstances, when they use the word this time last, and this extension, my lords will get, this is 16/3/2023, and this extension order that my lords have just perused, this is last extension up to 17/1/2023. So this indicates again that we were continuing irrespective of this antim extension, because field officials were utilizing our services, because we cannot be dispensed with, there is no other person, entire scheme will stop.
The Learned Counsel has submitted that the action of the respondents in taking work from the petitioners as regular employee throughout and subjecting them to renewal of contract from time to time and most of the time post facto is exploitative in nature, in as much as the petitioners has been deprived of the regular service benefits which are otherwise available to regular employee. He submits that the respondents acting as a model employer cannot act in the manner they have acted in the present case.
Now, having regards to these background facts, when the annexure 18 was there on this report of this case, annexure 18 page 58, by which in the first writ petition, this honorable court was kind enough to grant protection to the extent that if the petitioners are working, they will not be removed without the prior approval of this court. Having regard to a specific amendment made in paragraph 27 of this case, kindly have a place on page 27, paragraph 27, wherein we have specifically pleaded that he is still working. Working means, it does not mean that if I am coming to the office, you will not take the work from me, I am not working. I am available. In the entire record, there is no order of removal or termination or dispensing of the service. Honorable Supreme Court clearly has held, in the night I have researched, that oral dispensation of even a daily wager is not recognized in law. You have to pass an order. We are in a arena of legal administration of not in oral kind of things. So what happened was this honorable court, having regard to paragraph 27, having pleasure, kindly see paragraph 27, page 16 of my writ petition. Lordship has got it, that is stated that the petitioner is still working on the post of junior engineer agriculture, as is evident from attendance report from month April 23 on the Aadhaar enabled biometric attendance system, has made representation dated 15/3/23 to the good office of the Soil Conservation Office Chatra for continuous of service, which has since been appropriately forwarded by the Soil Conservation Officer Chatra by so and so. This averment has not been denied in counter affidavit which has been filed in December 2020, October 23. Kindly see the counter affidavit.
Yes, the Learned Counsel has referred to paragraph number 27 of the writ petition to submit that attendance report was generated in the month of April 2023 also, and a representation dated 15/3/2023 was made to the goods offices of Soil Conservation Officer Chatra for continuation of the services of the petitioner, which was duly forwarded by the Soil Conservation Officer Chatra by his letter dated 16/3/2023 as contained in Annexure 6. The letter dated 16/3/2023 and the representation of the petitioner is contained at Annexure 16, wherein it has been mentioned that the petitioner is working as contractual employee and his contract is expiring on 17/1/2023, and therefore the petitioner had made a representation for extension of contract, which was forwarded for extension by letter dated 16/3/23.
Now let us kindly see the counter, which is filed on 4.
It is admitted.
I am on different date minutes. Why I am saying so much? This is filed on 4th October 2023.
Okay.
They does not deny this, that I am not working. They could have said, he will dispense with, we have passed the order of termination. Under the law clause non-traverse. By virtue of this counter dated 4/10/2023, this statement is stand admitted.
The Learned Counsel submits that the counter affidavit filed in the present case is dated 4/10/2023, and no statement has been made in the counter affidavit that the petitioner was ever discontinued or any order to that effect was passed. Rather, the continuation of working of the petitioner stood admitted in the contract.
Now, my lords, therefore, what occasioned us to file this contempt petition which is connected with
Contempt बाद में
छोड़ देते हैं हुजूर उसको, खाली ओरल में हुजूर जो कन्विंस करना चाह रहे थे, इसीलिए हुजूर हम लोग कह रहे हैं कि कोई ओरल डिस्पेंसेशन है नहीं, मेरा डायरेक्टर बहाल करते हैं, डायरेक्टर सब होता है। फील्ड ऑफिसर से अक्टूबर में आया लेटर, जब सोको इशू करके ही नहीं है डायरेक्टर साहब कि आप एक्सपायरी के बावजूद कैसे काम ले रहे हैं। Some of the most
What
of
is the date of that
Soko's order? Soko's.
What is the date?
That is lost. This was 31/7/2023.
What is the date of interim order?
My order is 17/7/2023, and the first one is that was 14/2/2023. 14/2/2023. Then in my case 17/7/2023, and in the third case, interim order was refused because I have not filed the amendment petition first. I have not challenged this order, this 31/7. Therefore, in third case, my IA for stay was refused with respect to those 4 persons.
The Learned Counsel submits that the interim order in this case was passed on 17/7/2023, and on that day the petitioner was working, and therefore by virtue of such order the petitioner ought to have been continued, but a letter dated 31/7/2023 was issued by
the director to all the field officers.
By the director to all the field officers as to how the various persons were continuing in service without any extension order.
Now, what happened? Pursuant to this Soko's order, all the field officials except Chatra official replied that we are taking a work because we are in ardent need of their hands. By all scheme will be stopped. We cannot dispense him. Therefore, and since all the time the post facto extension has been granted, we are taking the work. Chatra did not reply at that time.
They are all from Chatra?
No, in different districts. Somebody is Dumka, somebody is Garhwa, somebody is Latehar, all across the state.
सबका कहानी mix करके एक ठो बना दीजिए. Why different petitions from different districts and different stories have been clubbed up?
I'm justifying this. I'm trying to satisfy this.
Then what happened? You just
Then what happened? Chatra did not reply. Chatra replied in October. देखिए हमको इस सोको से मुक्त कीजिए, हम उनको 15/6 से काम नहीं ले रहे हैं, और उसी में इसको बाहर कर दिए, बाकी सबका एक्सटेंशन दे दिए.
You were in Chatra?
I was in Chatra.
The Learned Counsel has submitted that all the field officers of different districts had responded to the letter dated 31/7/2023 issued by the director stating that the work was required to be taken from the petitioners as they were involved in developmental work. But so far as Chatra district is concerned, the authority tried to cover up the fact regarding taking of work from the petitioner by issuing a letter that no work was being taken from the petitioner since June 2023.
15/6/2023.
Since 15/6/2023.
That letter came on 8/8/2023.
And such letter was issued on
8/8/2023.
8/8/2023.
And was 28/8/2023.
And also on 28/8/2023. And consequently, all the persons in the other writ petitions were continued by virtue of the interim orders passed by this court, except the present petitioner, although the interim order was passed in favor of the petitioner, namely Bholanath.
In the same line to that of the 14/2 order, Lordship. That is the Mullas order.
Okay.
So this is the Mullas, this Bholanath Mullas story. Now Mullas, the third writ petition, my Lords will kindly have a pleasure of that. This is the Mullas
WPS number
3621 of 2023.
WPS number 3621 of
2023.
2023.
Now kindly have a pleasure of it, Mullas.
How many persons are there?
4 persons only.
This writ petition has altogether 4 persons.
In this case, my lords.
What is the period of extension? Where is the letter of extension?
Yes. Same, my lords. This is next 15. Page 51. Same.
51. The learned counsel submits that similar order इसमें तो लास्ट चांस नहीं दिया हुआ।
लिखा हुआ सेम लेटर जो पढ़े पहले 51 में फर्स्ट पिटीशन में दिस इज द सेम ऑर्डर
50 में
51 पहले का सारा एक्सटेंशन है लॉर्डशिप पेज 14 से
The learned counsel submits that in this case the same letter of extension dated 13/12/2022 is involved, and since the letter of extension was by way of last chance, therefore the writ petition was filed on 12/7/2023.
Lordship will find serial number 5, 6, 10 and 11 are in this writ petition.
The serial number 5, 6, 10 and 11
are in this petition.
Of the persons mentioned in Annexure 15 to the writ petition are the petitioners in the present case.
And the rest below 7 persons are the petitioners in the first case 129.
And the rest 7 persons are the petitioners in the first case being WPS number
129 of 2023.
129 of 2023.
And so only Bhola Blos is the separate extension. Lordship has fine. Post facto 2 years.
Okay.
So Bhola was segregated since beginning for one or other reason, my lords. We do not know.
In this case, the interim order was refused.
Refused. Can you see that order?
The learned counsel has also submitted that the interim order the interim order was refused to the petitioners by order dated 16/8/2023.
With liberty to file a fresh IA.
With liberty to file a fresh interlocutory.
Fresh IA challenging the order of this supposed order that was issued that my lords has just referred 31/7.
Challenges. So ऐसा लिखा हुआ है कैसे? नहीं लिखा हुआ है. So I will not say anything on that. That's right. Then, okay, these facts are complete.
Lordship, it's complete, my lords. And only thing, my lords, after these was during tenure, this was rest 11 persons are being extended. The extension later has been annexed by the respondents.
All the 11 persons.
All the 11 persons. All the 11 persons have been extension later.
In spite of the fact that there was a denial of interim relief.
Yes. With respect to these 4 persons also they got extension done.
The learned counsel submits
Let Bhola is out.
The learned counsel submits that in spite of refusal of interim order by order dated 16/8/2023, all the 11 persons mentioned in letter dated 13/12/2022 has been granted the extension
for 1 year.
For 1 year from
last expiry in this letter. This is
कहाँ है वो letter?
वो letter जो हम लगाए हैं annexure 12 of my contempt petition. Lordship will file
which he has annexed along with annexure
12 of my contempt petition.
12 of contempt application being contempt case number
785 of 2023.
785 of 2023. Page number बताइए.
Page 46.
Ten, 11 नहीं.
Page 12 minutes.
हाँ,
पेज 46 annexure 12. इसमें 10 आदमी के नाम है.
हाँ, और 10 persons except भोला राम नहीं.
एक आदमी जिनका कि अप्रैल तक था टाइम टेन्योर बचा हुआ था, उनका अलग से निकाला सेपरेट.
वो नहीं है.
वो जो हमको नहीं मिला था, लेकिन
just a moment.
For that he is separate.
एक second please hold on. The letter of extension is dated 25/8/2023, annexed as annexure 12 in the contempt application, which is in connection with altogether 10 persons, except one whose name has been mentioned in the earlier letter of extension dated 13/12/2022.
ये हो उनका सिंगल हमको कल मिला है, मेल में आया था। उदय कांत का एक आदमी का यहाँ
A copy of the said one person, namely Uday Kant, has been produced before this court during the course of hearing. Yay?
Now, further also they have extended with respect to the relevant persons.
देखिए ऐसे नहीं चलेगा ना. It can't be like this. Okay, that is sufficient. We are not concerned.
Only was I making a statement that is still another extension they have granted for these relevant persons.
अब interim order है तो देना ही पड़ेगा ना.
Therefore, what occasion for me to trouble my lords for Bholanath was this situation. Because this is
I have understood. Bholanath case we have understood.
Was situation. Now, in this background, what I beg to humbly submit, that all are entitled for Bhol's continuation within the meaning of Article 21 of the Constitution of India, Millers, as has been held in the case of Millers Kamal, the state of Jharkhand versus Kamal Prasad, wherein their lordship has considered this issue of the engineers itself, who were initially engaged as a junior engineer, and then Millers upgraded to the assistant engineer, all on ad hoc nomenclature. But similarly, were granted
upgraded to assistant engineer.
All nomenclature ad hoc.
All ad hoc.
Ad hoc.
What is the difference between ad hoc and contractual?
Because all this is the species is the contract, daily wager, etc. The species.
What is the difference between ad hoc and contractual?
Ad hoc is the melos that contemplates that it is the need based. Ad hoc contemplates need based melos. I have read one judgment where the ad hoc has been defined. It is a need based, only nomenclature. But if the actual melos,
but no time period.
No time period. Plus, actually, melos, after it's a jurisprudence melos, we say that by lifting the wheel, if the Honorable Court ultimately finds that it is a exploitative approach of the respondents who are in need of the regular employee, appointed in the regular manner, treating them regular for all purposes, but
so your appointment itself is incorrect. Your appointment on contractual basis is itself incorrect. They should not have appointed you on contractual basis.
No, this is what they can argue, but they cannot argue against themselves. My appointment is perfectly justified because as per the advertisement.
That's right.
What I beg to submit, that certain condition in the MLOS contract, which are in teeth of section 23 of the contract as void of an issue, will not override Article 14, 21, 16 MLOS. Then all these aspects have been dealt with.
So a person who is appointed on contractual basis, the period is void of an issue.
No, not period MLOS. Certain conditions
Which condition
you can be dispensed with at any time.
No, it is not their case. It is not their case. No, it is not your case also that you have been dispensed with in the midst of the
counter. They say that you are contractual. You have no right of continuation vested, no right of regularization. And in the contractual term, it is written that any time you can be dispensed with, you have accepted with open eye all these terms. Therefore, you have no right of regularization. All these aspects have been considered in the Milos Uma Devi case, and para 53 is the exception Milos to carve out vis-a-vis Article 21 of the Constitution of India and good governance Milos. And the Lordship says that no, once the appointment is bona fide, qualification is there.
By way of Uma Devi, was it one-time affair?
No,
or it was in perpetuity?
That was further explained in Milos ML Kesri case.
ML Kesri. Because the Jharkhand was not created at that point of time. The 10 years period would not expire so far as employees under Jharkhand is concerned. And therefore that period was extended.
That was Narendra Tiwari. In a Narendra Tiwari 2018 judgment, the Lordship said
things which you are not citing.
No, I have given the compilation of
you just refer to your judge. You have here this Kamal Prasad is the best case, no?
According to Milos, that covers me the case best Milos.
Okay. That is the best case. Let's deal with that.
on their judgments. And notice in the counter affidavit, there is no denial of any appointment, no para-wise reply, it is a totally vague reply.
No, we have, facts are over, you
Great.
come to the law straight.
Now kindly see this. Our first judgment that was I have given to your lordship, the division bench judgment of the Honorable Jharkhand High Court, which has decided the Kamal Prasad case. What has happened was the writ was lost. During the pendency of the writ petition, my lords, we were subjected for sopage of termination. This Kamal Prasad and others. And therefore, the writ petition by itself was dismissed. That's against the sopage, you go and file a reply. Our contention was that since the sopage by itself is a premeditative sopage, and since on the other hand, these persons have continued for pretty long time, more than 10 years, they should be regularized instead of termination. That was not found favourable with the Honourable Single Judge Miller's matter went on in the LPA. What the Honourable LPA court has held, I'll read from paragraph 21 onwards. Because facts, etc., may kindly examine. Paragraph 21 onward, plus kind of a pleasure of it.
Yes.
The core question involved in this case was whether, in the above facts and circumstances, the core question involved in this case was whether, in the facts and circumstances, the petitioner's services should have been considered for regularization by the state government. The ancillary fact which diverts the main question is that the petitioners during this period got the opportunity of appointment on the same post under regular selection through the Public Service Commission, wherein once they failed and on second occasion they did not participate, whether a person who did not accept any other appointment during the period of his ad hoc and temporary appointment and served for more than 10 years, in the case for the more than 20 years, stand disqualified from the regularization of his services on account of that he did not participate in any other appointment process, when an Advocate General vehemently submitted that this reflects towards the conduct of the writ petitioners and therefore there cannot be any reason for sympathy and regularization of their services. We are not in agreement with the view expressed by the learned Advocate General because of the reason that person who was in temporary or ad hoc service failed or did not participate itself may not be a ground to refuse consideration of regularization of his service when even after failing or not availing such opportunity, the employer did not choose to dispense with the services of such person without any restraint order of the court and continued with persons in employment voluntarily for more than 10 years or more years from such person's failure to get appointment in regular process. The principle laid down in Uma Devi case fully applies to such ad hoc temporary employees because of simple reason that such employees were continued in service voluntarily by the employer for such long time. May I pause, your lordship? In spite of expiry of our contract period and in spite of no extension in advance, they were allowed to continue and thus they were constantly utilize their services.
This was not a case of contractual appointment.
No, it was also nomenclature was ad hoc.
No, that is why ad hoc, contractual, daily wage are different connotations altogether.
Therefore,
this is not a case of contractual
contract. What is not a contract? Temporary word is there, therefore the lordship has used the word alternative word temporary. Only not ad hoc. Temporary, the temporary employee. The lordship has conscious of this fact. Therefore, two interchangeable words are being used, all are temporary. So therefore, contract or this ad hoc all are temporary. The petitioner's employer had apprehension because of publication of other advertisement for recruitment on the post of assistant engineer, and that was valid, and just apprehension that this fresh selection may affect their job and their services may be dispensed with. Therefore, some of the employed persons sought interlocutory application was submitted before the Honorable Supreme Court, wherein an order of relax the age for the ad hoc temporary employee was passed, and the state in fact relaxed the age services temporary employed. The petitioners did not apply under this fresh advertisement. In our opinion, of the state would have taken a decision to dispense with the services of this employee immediately. Therefore, on account of availability of the regularly selected candidates, the action of the state may have been legal, but such plea is not available to the state after delay of 10 years. Is not the plea of the state even today, and only plea of the state is that the appointment given about 24 years from 87 was illegal, but that was only on apprehension, and that apprehension was declared by the state government when the state government replied to interlocutory application filed in WPS number 708/2005, Mod Narayan versus so indicated that apprehension of such employee has no location. My case is better, Millers. What has happened? The post against which they were appointed was a sanction post that was claimed by the other persons, unemployed persons. High Court refused, matter went on Supreme Court. Supreme Court says to advertise it, make a regular appointment.
With relaxation.
With relaxation. They did not apply, nor they were dispensed with. They continued working in spite of their appointment as a regular employee. Therefore, the Lordship ultimately held that you have never dispensed with their services. They are ardent need of the state. How can you now say that after this more than 10 years lapse that their appointment was illegal since beginning?
That's right.
That illegality goes because further the Lordship has held that this experience and their discharge of duty in the aid of the state will override this technicalities vis-a-vis Article 21. Let us have further paragraph 24-25. Plus 24 is the recital about the state of Bihar who were left out in Bihar. Now about 25 I will read, Lordship pleasure. Or Lordship so permit me, I will read 24 also.
Not
25 The contention raised by the learned Advocate General was that yet there is no precedent wherein any regularization has been ordered on the post for which recommendation of the Public Service Commission was required, and therefore the petitioners who are seeking regularization on the post for which recommendation of the Public Service Commission is required cannot be given, would appear to be attractive, but we are not impressed. A State Public Service Commission examines suitability of eligible candidate for the post and recommends the name of suitable candidates for the appointment, and this case is not the case of a state that these employees who are eligible to hold and render services on the post are not suitable persons to hold post, even if any recommendation of Public Service Commission cannot be dispensed with. Even then, suitability as one-time measure can be examined by the Public Service Commission without asking the employees to compete with the freshers of the present day. It is suffice to state that law is for the equity of justice, and where equity and justice are treated against the technicalities, then equity and justice are required to be given precedence over the technicalities. In the case where the regularization is required to be made in peculiar circumstances, that government's case is not that posts are not available. It is also not the case that work is not, and posts though they are available, the government voluntarily kept the employees in employment for about 30 years without compulsion or order of the court. Employees were paid not only regular salary but increments also. Consequential, there is minimum financial burden. So one of the issue was financial burden. Here also we are getting the skill set. Government never wanted to remove this employee, and sole reason given for present removal is that the appointment given by the state to these employees is now treated as illegal, and the government has power to terminate the services of these employees. Therefore, the state is terminating services. In such facts, the state first duty in consonance with Uma Devi case could have been to find out a way to make the appointment regular instead of taking help of technicalities of law only in one way, which is not expected of a model employer and a welfare state. It will be worthwhile to notice here that as back as in the year 1986, an act, the Bihar Gazetted Officers Ad Hoc Appointment Regularization Act 1987 was enacted to regularize the services of the persons whose appointment could have been given only on recommendation of the Public Service Commission. By that act, such employees who were appointed up to 30th June 1986, their services were regularized on posts which could have been filled on recommendation of the Public Service Commission, and these petitioners are appointee of the year 1987. If these petitioners' services could have been regularized by enacting such act as against one-time measure, which was required to be taken by the state government in compliance with the direction given by the Honorable Supreme Court in Uma Devi, and accepted the case of Emil Kesari. Now let us further, para 26-27. We are also not impressed by the argument of the learned Advocate General that the appointment of the writ petitioners will deprive any other person from the employment. It is worthwhile to mention here that normally a plea of discrimination and violation of Article 14 and 16 is raised even in a matter where employees have served for about 10, 15 and even 20 years. and even more, but ignoring this fact that even if services of such employees are terminated after 10, 15, 20, 30 years, whether we are giving the opportunity to those persons who were eligible 10, 15, 20, 30 years ago. Therefore, after lapse of this much of the period, it is doubtful whether the employer, particularly the estate and particularly the welfare estate, can raise such plea so as to deny the employment, and law can be interpreted in a manner so as to give all the benefits to the wrongdoers. In case where the large number of engineers have been given appointment consciously and there is no allegation of unfairness in appointment, an appointment which can be said to be tainted and is not out of result of any favoritism. Same is the case, Milos. We are not a backward entrant. We are the open mode entrant, Milos. There is no allegation of any misrepresentation or backdoor entry. No fraud, nothing. Now, Milos 27. In fact, the judgment of the Supreme Court are normally interpreted by the employer and the state government in a fashion that whatever wrong they may have committed for decades got the right to throw away poor persons or make a well-settled person a poor and employed person. In fact, the Uma Devi case, which has been considered by the Honorable Supreme Court in subsequent judgment of the State of Karnataka versus ML Kesari, as reported in 2010 9 SCC 247, it has been held by the Honorable Supreme Court that Uma Devi case cast a duty upon the government or an institution concerned to take steps for regulation of the services of those employees who have served for more than 10 years without the benefit of direction of any interim order by the court as one-time measure. In this case, it has been clearly held that Uma Devi case directed such one-time measure must be taken within 6 months from the date of its decision rendered on 6 April 2006. The welfare state should find fault in the service of these poor persons but could not read the directions of the Honorable Supreme Court delivered in the case of Uma Devi as well as in the case of ML Kesari. The loss 10 of 2829. The state, by passing the pre-decided order of termination of the services of these employees, is projecting itself to be a law-abiding state, projecting that it is obeying the Supreme Court and this court's decision, whereas in fact wants to take benefit of one event of the creation of the state of Jharkhand. At the cost of the repetition, we may mention here the writ petitioner eligibility at the time of appointment is not in question, nor the conduct of these writ petitioners was questioned for more than 25 years by the state government, then simply because that there is some indication in the order that competent authority by pass any order in relation to services of the writ petitioner, the state government proceeded to so cause notice and then pass the order of termination of the services of these employees, which cannot be justified. The contention of the learned Advocate General that so cause notice is not without jurisdiction or is not passed by the authority having no power are absolutely misplaced arguments, in as much as that the state wanted to take a decision to dispense with the services of the writ petitioner, then the state should have applied its mind and should have looked into all aspects, including why their services are sought to be terminated, dispensed with after 30 years of their services from the time of their appointment on the post of junior engineers, and why their services cannot be regularized and who have created this irretrievable situation. In this case, we lost 3-4 petitioners have crossed more than 50 years. All have crossed more than 40 years in our case also, by virtue of the lapse of time, efflux of time. The technicalities cannot come in the way of the writ petitioners, and contention of the Advocate General that the order of termination of services has been challenged cannot be entertained in view of the fact that even if the provision of Civil Procedure Code is not applicable to the writ proceeding, yet principle of Civil Procedure Code are well applied in the procedure for the writ petitions, and Order 7, Rule 7, CPC empowers courts to take note of the subsequent events and mold the relief accordingly. The writ jurisdiction also empowers the court to take note of the subsequent events, grant the relief in accordance with the changed circumstances. The petitioners in the writ petition in Para C clearly prayed for regularization of their services and clearly stated that in the state of Bihar, in which state the petitioners were appointed, the similarly situated employees are continuing in service. Therefore, the relief seeking continuation in the service clearly take care of all the hurdles coming in the way of the writ petitioners. And when we are of the considered opinion that the petitioner's services should have been regularized, then any hurdle coming in the way of the petitioners created by the respondent during pendency of this LPA cannot stand and come in the way of relief. Therefore, we exercising our supervisory jurisdiction pause and set aside the order of termination of the services of the appellants dated 24th August 2011. The The learned single judge was impressed by the argument of the state that the petitioner got opportunity for appointment twice in earlier occasion, but we are of the considered opinion that fact was not relevant in the facts and circumstances of the case, which we have already explained above. Therefore, the order of learned single judge cannot be sustained in view of the reason mentioned. LP is allowed, impute notice will set aside, so and so, so and so. Order of termination, petitioner so-called notice was applicant shall be entitled for all consequential benefits. Now notice what happened. So there's two things is here, Millers. My case is better, Millers. There they were granted opportunity for commission facing etc. Yet honorable court says that no. 10 years passed, 15 years passed, irretrievable situation. They cannot be compelled to compete with other persons. They are a separate class now. It is not a case that they are not eligible, any allegation of malafide or misrepresentation is there. Initial entry is bad in law. So equity is in their favor, and wherever the equity and justice will conflict, the equity will prevail, Millers. This is what the ultimate finding, Millers. Now, against this judgment, Millers, the state went on to Supreme Court. Supreme Court, Millers, extended the relief what has been granted by the Millers Honorable High Court by saying that not only they are entitled for regulation from 1987, that is the ad hoc upliftment to the Millers assistant engineer, rather from 1981 itself when they were appointed as junior engineer. Now kindly be pleasure, Millers, of that judgment. But that is Millers second, third judgment, Millers. Normally it has been in the meantime 18.3. I will place later, Millers. This 10.9 SCC is the ML Kesari. First I will place ML Kesari, Millers, before that. Because ML Kesari, Millers, I am relying upon. This is the only judgment, Millers, up till now been, Millers, widely, Millers, taken as a, Millers, holding the field judgment on the aspect what is irregular and what is illegal.
No, it is not a case of illegal.
Grateful, Millers.
So you need not refer to any case.
So, Millers, paragraph 7 of this judgment ultimately says only what is the requirement for regularization. Kindly see, Millers, paragraph 7 of this.
Para 7?
Para 7. It is evident from the above that there is an exception to the general principle against regularization. In stated in Uma Devi, following conditions are fulfilled. Kindly see, Millers. The employee concerned should have worked for 10 years or more in duly sanctioned post without the benefit of protection of the interim order of any court or tribunal. In other words, the state government or responsibilities should have employed the employee and continued him in service voluntarily and continuously for more than 10 years. This I satisfy your lordship. In this present case, my lords, we satisfy this.
Don't seek an answer from me. You say that you have satisfied.
Gratefulness. Then was 2. The appointment of such employee should not be illegal even if irregular. Where the appointments are not made or continued against the sanctioned post, or where the persons appointed do not possess the prescribed minimum qualification, the appointment will be considered to be illegal. But where the persons employed possess the prescribed qualification, was working against the sanctioned post, but had been selected without undergoing the process of open competitive selection, such appointment are considered irregular. I humbly submit, Millers, that my case is even better than this. We are working in sanctioned post by the competent person, and our appointment is also by the open competition. Therefore, I humbly beg to submit for my Lord's kind's consideration that this petitioner fully falls within the sweep of paragraph 7 of this Millers MLKC. Then Millers paragraph 9, 8 and 9 small paragraphs. Uma Devi cast duty upon the government to instrumentality to take steps to regularize the services of those irregularly appointed employees who had served for more than 10 years without the benefit of protection of any interim orders of the court or tribunal, as the one-time measure, directed that such one-time measure must be set in motion within 6 months from the date of its decision. So, the term one-time measure has to be understood in its proper perspective. This would normally mean after the decision in Uma Devi, each department or each instrumentality should undertake a one-time exercise, prepare a list of all casual daily wages ad hoc employees who have been working for more than 10 years without the intervention of the courts and tribunal, subject them to process verification as to whether they are working against the vacant post, process the requisite qualification for the post, and so regulation. So I'll pause here, Millers. What happened was that in 2015, this state government came out with one circular, and they made the cutoff date of 2006 in NN Tiwari case members. They rejected the claim. Matter went on to the Supreme Court. It was 2018 judgment was 2018 8 SCC 238. I brought it was. Their lordship held that this is the absurd proposition that anybody who will complete the 10 years in the year 2006 when the state has created in 2000 itself. So the purposive interpretation would be that 10 years working after the creation of the state of Jharkhand. And the matter was remitted back to the state of Jharkhand to reconsider the matter. Again the state rejected. In spite of that clear-cut direction by the Supreme Court, in paragraph 10, the remand judgment that was 2018 8 SCC 238.
Give me that judgment. 2018 8 SCC.
I'm just passing with most two judgments. This Supreme Court judgment and the Honorable High Court judgment, which have been passed following the same rules.
2018 8 SCC 238. Para number?
Yes. This is paragraph 10 numbers. Paragraph 10.
What does this date means? On the date of 10 years service, on the date of promulgation of the regularization rules.
Grateful news.
What was the date of regularization of rules?
There's two aspects in this case. Paragraph 10 says what? Under the circumstances, it says two things. The state should have considered that if they have completed 10 years, even as on date of the issuance of rule, the state should have considered. Or else, 10 years service is enough. Can you see the language mirrors? That has been considered. Under the circumstances, we are of the view that a regularization rule must be given a pragmatic interpretation, and the appellants, if they have completed 10 years of service on the date of promulgation of the regularization rules, ought to have been given the benefit of service rendered by them. Full stop. Now there is another separate sentence for us. If they have completed 10 years of service, they should have regularized unless there is some valid objection to their regularization like misconduct, etc. I am relying upon this part. So the lordship ultimately culminated that 10 years is the crux, no misconduct is the crux, valid entry is the crux, valid qualification is the crux, valid appointing authority is the crux, and you cannot revert back if there is no misrepresentation, etc. So this is the judgment that has been followed, and this another judgment will High Court will have next just below that. But before that, I will place this Supreme Court Kamal Prasad after lunch.
No, you finished it. We have read it.
It
has upheld the judgment.
The certain addition.
No, which paragraph? Just refer to
The
the
lordship
paragraph.
has considered the Olga Teli case in this case.
That's right.
And
that is the principle of law which has been considered.
Grateful
What further relief has been granted over and above what was granted by the High Court?
High Court has granted regulation from 1987. That is the assistant engineer.
Okay.
When we were upgraded, this Kamal Prasad and others were upgraded for the assistant engineer.
Okay.
Supreme Court says no, you grant regulation from 1981 itself when they were engaged.
Where is that paragraph? That is the effective date of regularization.
Effective date.
Yes. Which is that paragraph?
Because this judgment was followed by another judgment in a contempt.
We are not. Once you place that judgment, you stick to that judgment.
I am sticking, Lordship. Just I am explaining. This judgment has been read along with the contempt judgment, wherein the Lordship has explained.
First, we will read the judgment
of Kamal Prasad, then the contempt wherein this judgment was interpreted by the Supreme Court themselves.
Where is it?
Paragraph 30 onward.
Onward means what?
30 onward, there is a consideration of everything.
No, you just tell us that you just said that now the effective date would be 1981. It has been held here.
Yes.
Show us from where it is.
I need some more time, Lordship. Lordship, give me
हम तो पूरा जजमेंट पढ़े हमको मिला नहीं इसीलिए आपसे पूछ रहे हैं.
हाँ इसलिए इसमें ये लोग नेक्स्ट नहीं किया. हम बोले थे उस लोग को नेक्स्ट करने के लिए.
आपको सुन लिया काफी 1.5 घंटा सुन लिया.
I'm deeply obliged for that, Lord.
Now I will hear the respondent post lunch. आपका आर्गुमेंट और कुछ नहीं बस हो गया. हम सुन लिया आपका सारा आर्गुमेंट.
पैरा नंबर जो लिखा हुआ था इसमें कमल प्रसाद वाला जो जजमेंट है.
लेकिन उसमें ऐसा कहीं नहीं है कि कोई एडिशनल रिलीफ दे दिया सो।
नहीं वो हुजूर हम बता रहे हैं हुजूर
आप
ये इसके
बता
खिलाफ
रहे
जो
हैं
कंटेम्प्ट
लेकिन
फाइल
दिखा
हुआ
नहीं रहे। आप बता रहे हैं लेकिन दिखा नहीं रहे।
जजमेंट तो तुरंत ला के दे देंगे हुजूर, ऐसा नहीं है। अब हुजूर इतना शॉर्ट टाइम में हुजूर का आदेश हम तैयार
शॉर्ट टाइम
कोशिश
नहीं,
किए
आपको
तैयार
पूरा
होने
टाइम
का।
दिए। आप चूंकि आपको शॉर्ट टाइम दिए थे, आपको बिना डिस्टर्ब किया तो
कल शाम में हुजूर हम जब हुजूर का आदेश हुआ कि आज ही सब तैयार कीजिए आप,
तो
हम
हर एक को ऐसा चैलेंजिंग काम नहीं देते हैं ना। हम लोग को पता है कौन क्या कर सकता है।
solely trust upon me and trying to with respect to my lord's trust, I will, I will.
You argue in the second half. I will be back at 2:15 sharp.
And the rejoinder I will only 2 times.
ठीक।
Madam, one detailed notes of argument about
Which case?
Tomorrow it is listed your caste certificate.
Listed for?
Here, final disposal. It
Final
was to be filed today itself.
फाइल कर दीजिए। देखिए जरा कौन से केस का।